Justices of the Appellate Division Court Department. Hear ye, hear ye, hear ye. All persons having business in this court, draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. First case on the calendar for oral argument, number 201, People versus Charles Jones. Morning.
Good morning, Your Honors. Sean Hennessy for the Legal Aid Bureau of Buffalo. I am here on behalf of Mr. Charles Jones, the appellant. A caveat about my argument, I'm really just directing this toward the plea and sentence for the death of his mother, Alita Atwood. And my first argument is that the plea was unconscionable. If you look at contract terms, and I know we're hesitant to do that sometimes at the appellate division and criminal law in general, but they are somewhat applicable to pleas. This plea here was substantively unconscionable. You just need to look in the face of it to see. What did my client give up as a result of the plea? Well, the right to a jury trial, the right to confront witnesses, to take the stand in his own defense, his statutory right to review legal errors in his case on appeal, his right to challenge the harshness and excessiveness of the sentence, and most importantly, at least in this case, was his right to a DVSJA sentence mitigation examination hearing, whatever you want to call it. Now, what did he get in return for that? Well, he got 2 consecutive 25-year sentences per the record. He was near 30 at the time. So ostensibly, this was a life sentence to him. I mean, we can talk about, well, it wasn't 25 years to life. Well, it's still consecutive 25-year terms. That's 50 years. He'll get out when he's around 80. In addition to that,
At least it gives him a shot at getting out. He would have 2 life sentences back to back, conceivably, if he went to trial.
I agree with that, Your Honor.
He's never, ever getting out. So this, look, he's in a bad spot. He murdered 2 people.
I understand that.
No defense as to the guilt. So yeah, he had some bad cards, right?
I understand completely.
But it sounds like you want to keep intact the one plea, the 25, 25 with respect to the girlfriend that he murdered.
Yes, that is
You
true.
want to peel off the one on the mother and try to get DVSJA sentences.
That is correct.
But this was a package deal, and wasn't the deal on a Farrar basis, meaning if it's not 50 to life, then the people, then you go to trial on both?
It was, Your Honor. But it still doesn't make it not unconscionable. I mean, I know it was a Farrar basis. I know at least the lawyers knew what the deal was. But again, I mean, what was the bargain here? I mean, I agree with you that, okay, he's not going to be in there for life, but getting out at, whatever he gets out, late 70s, 80, I mean, isn't that ostensibly life?
If we rule in your favor, don't we have to send him to trial on both? He can't pick and choose.
I understand that. And I would ask for you to vacate this plea.
He wants to go to trial on both.
He would go to trial on both. I mean, that's another thing. He really wasn't given the opportunity. I mean, throughout his plea and his sentencing, he didn't want to. I mean, the record is clear on that. And I didn't raise that in my brief because I thought I had stronger arguments with the DVSJA and unconscionability. But I mean, as far as his mother goes, at least, I don't want to ever say that there's a murder that's justifiable. But if we look at his background, and I urge this court to really look at his background.
We did. Look, I think there is some evidence there of the abuse by the mother. That's one factor
Yes.
for the DVSJA. He's got to get past the second factor, is that it was causally related. Even if he does that, he's got the third hurdle, which it seems zero chance that this judge would ever allow him to get over the third hurdle, which is basically that it's in the interest of justice to give him a break on the DVSJA. So yes, he gave up his hearing for that Domestic Violence Sentencing Act. Didn't sound like that was a big sacrifice because the odds of him getting relief on that are slim to none.
But at least he was entitled to a hearing, Your Honor. And that's the problem here is, okay, there is a discretionary component built into DVSJA. I understand that. And if the court reviewed it and said, no, you don't qualify, then so be it. But he wasn't even given that opportunity here. And, you know, there's a case, I mentioned it in my brief, and Ms. Sloan does as well, that's going to be heard by the Court of Appeals.
March 12th.
March 12th, yes. That's Hudson. And they're going to clear up some of these issues, hopefully, as to whether or not you can waive the DVSJA, you know, the discretionary component, all that.
But it's the argument that it's not waivable. And here the court spent, it looks like more time on that in terms of the waiver than the waiver of appeal. But in any event, the issue before the Court of Appeals will be whether or not that's non-waivable. If that's the case, that would certainly apply here, right?
Agreed 100%, Your Honor. And that is part of my argument as far as that goes. And I don't want to get into the weeds with it too much because it's going to be decided.
Is that in the brief before the Court of Appeals?
Yes, it is, Your Honor. It is, Your Honor.
So if Hudson goes the way of the defense, then you ask us to hold this case, so we would have to follow it, and then your client gets to go to trial on both counts.
Yes, I would ask for that, Your Honor. Yes. I've spoken with them, and yes, that's what I would hope at least that Your Honors can hold any decision they issue on this until the Court of Appeals decides that, and then we go from there.
April or so.
Yeah.
Mid-April. All right, anything further?
No, Your Honors, I think you have it. Thank you very much for your time.
Thank you.
Good morning, Your Honors. May it please the court, Tabitha Salonen for the people. Now, contrary to defendant's contentions here, the plea entered into is not unconscionable. That is a contract law standard, and is the people's position that unconscionability really has no place with respect to a plea agreement.
Do you agree that Hudson's on point? The case at the Court of Appeals?
Yes, Your Honor.
Would it not make sense for us to wait and see what they do there? Because if they say you can't waive DVSJA a hearing, then that we have to follow that.
Your Honor, I would happen to agree that that this court can wait certainly for the Hudson decision. I actually think that the facts presented in this case are very similar to Hudson, apart from the fact that in this particular situation, the DVSJA contention is not preserved, whereas in Hudson, it seems to have been. Here, it also seems as though as previously stated, the court went through the DVSJA waiver it went through it an ample amount throughout the record. The record shows that, and it would be the people's position ultimately that a defendant can waive their right to a jury trial. They can waive their right to an appeal. They can waive their right to a 30 time. The nature of a DVSJA hearing is no greater than those actual rights that can be waived here.
A defendant can waive YO.
Yes.
But
Well,
why not just wait a couple of months and get the definitive answer on whether a defendant can waive DVSJA? Why not just hold this, see what Court of Appeals has to say?
Sir, this court can certainly do that, Your Honor. I would ask in that situation if the people could submit a post-argument submission with respect to the Hudson decision, just to show the similarities and or perhaps the differences.
After the Court of Appeals releases Hudson?
Yes, that's correct, Your Honor.
Yeah, I would. It's not unreasonable that both sides could opine as to the meaning of the Court of Appeals decision, Hudson, what it affects, as long as it's close in time. You know, we can't hold this case forever.
Understood, Your Honor. Just if the court was waiting for that, I would like the opportunity to do so if the court would
Sure.
allow. Thank you.
Is it your position that if Hudson goes the other way, it turns out that Court of Appeals rules that you can't waive DVSJA, would that vacate the entire plea, or would it just go back to be resentenced after a DVSJA hearing? See if it applies and then the sentence is modified, but the plea itself isn't vacated. Is that your position, or is your position that we'd be right back to square one?
Your Honor, it would be the people's position again that this is unpreserved because it was discussed at length on the record. The domestic violence assertions that are expressed on behalf of defendant are not particularly new here, and there was not an objection to the waivability of a DBSJA waiver on the record. So I don't think that in this situation, it would be appropriate actually for this case to be sent back.
So is it your position that unless the Court of Appeals says, regardless of whether the case is, an objection is preserved, that you're gonna say it's distinguishable? Because
In-
that case, it was preserved, and here you're arguing it's not. So even if they say, yeah, in that case, Hudson, they were entitled to the hearing.
That is our position. I would say that that's the major difference here, and preservation is the first step.
I don't understand what you mean by preservation. You're saying the defendant in Hudson objected to the waiver and said, I can't waive, but I'm going to waive anyways.
What I'm saying is that here, the domestic violence assertions on behalf of the defendant were discussed as a part of the plea agreement leading up to the plea agreement, and the court was very aware of such, and the defendant still decided to go forward with executing a signed DBSJA waiver and not objecting to the waivability of such.
I think what the Court of Appeals is going to decide is that even possible? Is that waivable? We understand your point, and it sounds like neither side objects if we hold this for 2 months and giving you the opportunity to weigh in post Court of Appeals. And then we'll go from there.
Sure, Your Honor. Just on that point, if I may just point out one practical thing. Here, the lower court judge is acutely aware of an experience with respect to the DBSJA waiver. It is sort of pioneer in issuing decisions. She issued one of the first decisions that granted relief under DBSJA. So as a practical matter, due to the discretionary language that is found within the permissible language of the DBSJA statute here, as well as what the Assembly discussed with respect to the intention of being that it be discretionary and provide an option for judges. I would support that. It is important here. With respect to the validity of the appeal waiver, I would again say that the appeal waiver is valid and enforceable with the totality of the circumstances and reading of the record. And I also don't think that there's any alleged conflation as defense contends within their brief. With respect to the sentence here, I think that it is very appropriate and should not be modified. The valid appeal waiver and DBSJA waiver set aside. These are consecutive, determinate, 25-year terms for 2 killings, 2 brutal killings for that matter, and on different dates and in different locations. And they are certainly within the statutory bounds and the plea terms expressed within the record. The crimes and the negotiated outcome do not warrant the interest of justice standard. Respectfully, Your Honor, any modification to and or disruption of the sentence and the Farrar plea would not be warranted here. Additionally, the mitigating factors were considered at sentencing as previously discussed and do not warrant. Again, the defendant avoided life on the back end here. He received a temporal sentence, and he had the opportunity to not accept this plea. The unique positioning of the procedural history here, and that there was a whole entire evidentiary hearing held after he originally pled guilty to the charges. He's acutely aware of what his odds are at trial. And in fact, it's my understanding from a fair read of the record, there were motions of limine that were ultimately argued, and I think a jury was present. So he was well on his way.
We understand all that, and we will take a look at all the arguments in depth.
Okay. If there are no further questions, Your Honor, the people would rest on their briefs.
Thank you so much.
Thank you.
Case number 203 is People versus Jonathan Sanchez. The appellant has submitted. Respondent is arguing virtually. Bassett, good morning to you. Your opponent has submitted. You may proceed if you wish. You have to unmute yourself
Okay.
first.
We're
There
all
you go.
set. Good morning, Your Honors. David Bassett for the people. I wanted to make myself available in case the court had any questions in this case.
The only issue I think is debatable is the sentence. He gets 50 years to life. Killed one person. I know he shot another. Seems other similarly situated defendants got a lot less. One guy got 30 to life. Does this defendant deserve, is he 20 years worse than the next worst guy? That's the only thing that jumped out to me. I'm not saying it is, but it's a colorable contention on the harsh and excessive.
Well, our position is that these sentences were properly imposed consecutively. You have distinct acts, different victims. One is a murder, one is an attempted murder. And the people's theory and evidence was to show that defendant actually fired the killing shot here for the murder. And that, I think, distinguishes him from his co-defendants.
Yeah, I'm not sure the record, I'm not sure anyone knows which of the defendants fired the shot, but the consecutive sentence is definitely authorized. Just question 50 to life. Is that a bit heavy? We'll have to take a look at that, but we appreciate your time and we thank you for coming on.
Well, thank you, Your Honor. Thank you. Thanks to the court.
Case number 204, People versus Canuti, Ryan C. Canuti. Case 204. Mr. Keene, good morning to you.
Good morning.
Waiting for Mr. Green, and he is now with us. So, Mr. Keene, you may proceed.
Good morning. May it please the court. Brad Keem for Appellant Ryan Canuti. First, I'd like to discuss our ineffective assistance of counsel point. We discuss several errors by defense counsel. I'd just like to stress a few. At the Sandoval hearing, Mr. Canuti obviously charged with sexual abuse in the first degree. He had 2 prior sex crimes, attempted sexual abuse in 2012 and another sex crime in 2007. Defense counsel only objected on remoteness grounds. And in our second point, we talk about the prejudice involved in that, and really defense counsel's failure here in terms of our ineffective point is the failure to request a Sandoval compromise. The names of these crimes.
The court did make a Sandoval compromise, didn't they? The court did make a Sandoval compromise here, didn't they?
I don't believe so, Your Honor, unless I.
Didn't they allow the fact of the convictions, but not the underlying information with regard to them?
So in a crime like attempted sexual abuse in the second degree, the name of the crime itself reveals that it's a sex crime. Whether you can talk about the underlying incidents, it's almost irrelevant when the crime is attempted rape in the second degree.
Right. So you're saying compromise is not enough, but Justice Bannister is correct. There was a Sandoval compromise. You just say, given the nature of the crime, it doesn't really matter. You get into the facts. Once the jury hears sexual abuse twice, it's over.
It is totally over. And I'm sorry, Justice Bannister, when I think of Sandoval compromise, I'm thinking it is a felony in 2007 without the name of the crime. So yes, you're right that it is a different form of compromise, but yes.
I will say there's some head scratching moments reading this transcript. I'm familiar with this lawyer. And
yes,
some very just can't comprehend what was going on there with strategy. You mentioned one of them, but would that have led to a different Sandoval ruling if he had made these arguments?
I think in terms of Sandoval, it would have if he asked for just the name of the felony. And it really starts a domino because at jury selection, he's talking about, he's encouraging and applauding jurors who say that they want to hear both sides, which goes back to your point of very inexplicable strategy decisions. And
Because he knew at that time, well, the defendant didn't give his side.
Exactly.
Inexplicable, but we're not talking about perfect representation here, right? Like doesn't have to be flawless. He did some other things fairly well.
And the people make that point about cross-examination, but there was still so much that counsel did not understand about cross-examination and would say he'd make these side comments about not knowing, which in front of the jury, again, this is the jury, it just prejudices Mr. Canuti so much in the jurors' eyes. And then you
seem to think one of the most confusing parts was defense lawyers seem to be under the misapprehension that his prior bad acts were going to come in regardless of whether he testified. And the court kept directing him, this is Sandoval, not Molyneux. He didn't seem to grasp that concept, which is concerning.
Incredibly concerning when you're talking about a person who has these prior sex crimes and who, all intents and wanted to testify. His desire to testify is littered across this record. They talk about it at jury selection. They talk about it at the April proceedings prior to the actual trial. And then the sentencing issue. You certainly wonder about, the trial court says, 5 to 15, that's what you can receive. He ends up with 26, and nowhere in the record is the correct sentence parameters provided to Mr. Canuti.
On the record, right.
On the record. And I understand that
was he offered 5 years flat at some point?
5 years flat.
And he ends up with 26, reduced by operational law a bit?
Correct.
Now, I think one of your contentions is that the lawyer didn't explain the exposure here. Look, you got 5 years on this offer. You could be hit with 26. That, though, would not be a matter for a 440 based on matters outside the record.
So
I could say, look, my lawyer never explained this to me. Didn't tell me I could have gotten 5 and didn't say what the possible exposure was here. That's generally we deal with those not on direct appeal.
I think that what makes this record somewhat unique is this Mr. Canuti finally talking about it at sentencing and saying that he went to trial because this defense counsel said that he could win and that the offer was 5 to 25 and don't take it because we can win. And considering the aggregate of what defense counsel's performance here and his comments, I think that is enough that there wasn't a range here on this record that was adequately explained to Mr. Canuti.
But there would be a reasonable way to believe that you could win on this record. This case rose, and fell on the testimony of a girl who was 6 or 7 years old at the time, and now is only 10. And if counsel might have thought he could, make some headway with the credibility of a child of that age, there is a view of this case that if he had done so, he could have won this case. I mean, it wasn't impossible, here.
Certainly, the child's own relatives didn't believe the child. A few of the child's own relatives did not believe the child. So, Justice Bannister said, the lawyer, knowing that, it's not irrational to be going to trial here.
Certainly, I think the
weight to me is how he handled the trial and whether these claims are more properly brought in a 440 to me or on appeal. That's really what it comes down to, for speaking from me only.
Right. So I understand that our weight of the evidence point certainly speaks to the credibility of the complainant here. But I believe that if you look at the totality of the puffery and the outrageous remarks that are sometimes made here by defense counsel, that when you look at that in the totality, I think the record reflects that there isn't a way that Ryan knew what the actual sentencing range was. And even if the court thinks that that portion is more appropriate for a 440, there's still the litany of ineffective assistance of counsel that is reflected in the record that should provide him with a new trial, and where he does understand what the sentencing range is. And I think that's more in terms of judicial economy. I think that's the quicker result to get to where he needs to be.
Anything further? Okay.
Yes, just in terms of the sentence, I know we touched on it briefly, but he was offered 5. He does receive 26, which is reduced by operation of law, but it is just too incongruent to the offer made originally by the people, understanding that the complainant did have to testify, but when 21 additional years, it is just it's not.
Is it incongruent to the conduct that was proven here? And look, all sexual abuse is horrific. Just state that on the record. But there are gradations. Forcible sexual intercourse, rape, is worse than mere touching. Here, we don't have any intercourse. We don't have oral sex. We have 2 incidents of a finger inserted inside her. Horrible. Okay, don't get me wrong. But rapists are getting 15, 12 years all the time, and this guy ends up with 26.
That's completely our point, Your Honor, and this is a problem with all sexual sentences. They are horrible, of course, but there are gradations of these, and we can't have a near maximum sentence and consecutive sentences on something like this, where it constitutes an abuse of discretion that this court, I think, is uniquely able to correct.
Let me ask you this. Oh, no, go ahead. Okay. This particular defendant has a history, okay? A significant history for sexual crimes, okay? He was a level 3 offender at the time that he committed this crime. So wouldn't it be fair for the court to take that into consideration at the time that it gave defendant this sentence that seems harsh, but in light of his history may not be as harsh as it seems at first blush?
Well, Your Honor, I think that is certainly a factor. His history is certainly a factor, but knowing that history, the people still offered a 5-year term and seemed okay with that kind of sentence. I don't think that the testimony of the complainant is that 21 years of a potential penalty. I think that's pretty harsh.
Okay.
We'll take a look at that. We thank you. Let's hear from Mr. Green now.
Good morning, Your Honors. My name is Glenn Green on behalf of the New York Prosecutors Training Institute, appearing on behalf of the Livingston County District Attorney's Office. If I just address the sentencing first, since this is what we've just been talking about. As the court well knows, prosecutors are rarely happy to give a sentence of 5 years in a case with this seriousness in the defendant's background. You shouldn't judge the sentence offered by what the defendant really deserved based on his escalating behavior. He has an issue with, as his own statement to investigator Connor said, morality issues. And his background and record speak to those morality issues. And while the sentence is certainly harsh, it's not in isolation. It's not the first time that he had done anything of this nature where he's taken advantage of somebody young. In this case, his predatory behavior has escalated to somebody who's substantially younger. And to the extent that there's a sentencing disparity, it's more of a product. The prosecution rarely wants to put a young child on the witness stand in these very difficult cases, and acknowledging that this case is not the overwhelming case that a prosecutor would like to bring to trial. Sometimes it is what it is. That
So,
being
Mr.
said,
Green,
yes.
once the victim gave credible testimony, didn't everything change, the whole posture of this case change? And far as sentencing and the way the case was viewed?
Until there's a conviction, there's no certainty. And I would take as a prosecutor a certain conviction, and a difficult one as this one has. And, this speaks to the issue of ineffective assistance. And, counsel, his ability may be in question. Counsel's performance is really what's measured under the totality of circumstances. And he raised good points with respect to the child's affect, that the child liked the prosecutor, that there is an absence of corroborating evidence in this case. It really does rise or fall in large part on the testimony about what happened from the child victim in this case. Although the defendant made statements, and those statements were incriminating in terms of his morality issues, his lies about not having been left the child there, and the access to having access to the child rather. This is a case of the child's credibility, and so counsel, in the totality in terms of performance, brought out the issue of lying, which in fact is probably beyond what is appropriate. While a general reputation or characteristic, reputation testimony about lying is one thing, asking an opinion from another adult who's not there as an expert on lying, that went beyond what was probably permissible, but the attorney got it out and made a valid point of it in the summation, which was considered and rejected by the jury in weighing this case. So, in terms of the overall performance, and going back to the main theme of counsel's brief, the ineffectiveness, it's performance, it's not ability. And while there were some things, and we'll talk about the Sandoval ruling, that wasn't the best moment I've ever seen an attorney have in making a Sandoval, opposing a Sandoval application. That being said, the result was a fair and proper result in that it was not an abuse of the trial court's discretion to have denied any use of the underlying facts of those convictions, and limited the defendant to being cross-examined should he have testified to the crimes, the convictions themselves. And so that, in this court's prior holdings and the holdings around the state, is within the sound discretion of the court. So the Sandoval ruling, whether or not we got there in the most clear manner on the part of trial counsel, the result was the correct one and didn't deprive the defendant of meaningful assistance. It's not the but-for cause of his conviction, especially since the jury didn't hear the defendant's testimony. He wasn't prejudiced by his prior convictions being paraded before the jury because they never heard them. So this is not one of those cases where that became a factor in the jury's deliberation. Instead, the case was on its simple facts, which is a 10-year-old child testifying about what happened as a 6-year-old victim to 2 instances of abuse by the defendant in this case, and a little bit of peripheral testimony about the behavior and change of affect of the child from before the abuse to after the abuse, and then after the disclosure and the child's road to recovery. So this is what this case, really boiled down to. In terms of the, performance otherwise, he objected to the Molyneux, kept the Molyneux out. Pretrial applications, inspected the crime scene, and I think certain points that counsel raised about how he tried the case and his affect, he has a child victim in this case, and he didn't take an aggressive approach. He may have taken, for some attorneys' views, a too deferential approach in not wanting to put the child on the spot before the jury and make himself look like somebody who didn't care about the child. But that, I think, was his theme, and that's why some of the issues that appellate counsel has raised about trial counsel's performance really factor into the case. That he wasn't confrontational, he recognized the seriousness of the case, but he also was aware fully of what counsel points out to be the limited evidence in this case. But it did come down to the child's credibility and some of the peripheral testimony and evidence, and on that basis, counsel performed as a reasonable and competent attorney would perform on those critical points or critical issues. If there are any questions.
Thank you, Mr. Green.
Thank you, Your Honors.
Case number 205 is Cass versus Newell. 205.
Good morning, Your Honors. Andrew Miller from Webster Zani, appearing on behalf of the appellants, the Newell defendants. This is a rather unique appeal in some regards, in that for most instances, a respondent adopts the position of the trial court. And 99% of the time, the respondent comes up and says the trial court got it right, and this court should affirm. And in this instance, the respondent has really separated themselves from the trial court's decision and ruling. And that's because, in my view, there's a pretty glaring error in the court's ruling, which is that the court, I think, misinterpreted the terms of the option agreement at issue here. And the option agreement is quite clear. And when the respondent, plaintiff, needed to invoke his option rights prior to December 30th, 2020, or prior to the appellant divesting an interest in the property, or
They didn't try to do that till November of 23.
correct. And that's the central issue here, which is that the option agreement has a term. The term expires on December 30th, 2020, or after the appellants sell their interest in the property. I say property, it's really a company. And he never invoked his rights, and that's undisputed. And I'm sorry.
Confusion came in for the trial judge was looking at the second phrase of that when it says term in the option, the exclusive option agreement. And they place a lot of emphasis on the word exclusive. The option says this option shall expire at midnight, December 31st, 2020. Just as Greenwood said, wasn't exercised till some 3 years later. But then it says, comma, or so long as Newell shall continue to own 100% interest in Lakeview in the hotel. It sounded like the rationale here for why your client lost was Newell transferred an interest to his wife, and there was a perception that therefore defeated the whole purpose of the option. Is that what you gathered from the court's decision?
I think that's what the court ruled, and the reason that I think it's incorrect is because Cass still needs to invoke his right in a timely manner. The option agreement is exclusive to Cass, meaning the rights defined in that agreement only Cass can invoke. And
there's another clause that if he were to transfer that, you need your client's permission.
Yeah. So Cass does, it's undisputed. And the reason that I made an early summary judgment motion was to get in the record that Cass unequivocally did not invoke his rights until 2023. And so now he wants to claim that he can retroactively somehow enforce those rights. And his term just simply expired. And while he clearly had the exclusive right under that agreement, it lapsed. And the way that I read the court's decision, the judge talks about it preemptively preventing Cass from invoking his rights. And the error there is that you can't have a breach or you can't have negligence in a vacuum, right? So he needs to actively invoke those rights in order for there to be a breach. And so you could have a theoretical situation. We're dealing with theory here. And in fact, he didn't invoke his rights. And because he failed to invoke his rights, and there's a whole litany of cases that I provide, he doesn't have the right to come back and try to enforce the option agreement.
The exclusive option to purchase agreement was signed in February of 2015.
Correct.
The option had to be, as we discussed, exercised by the end of 2020.
Correct.
What if Newell, a few days after the agreement was signed back in 2015, February, transfers 100% of his interest to his wife? A, could he even do that without your client's permission? And B, if he did, does that defeat your client's right to exercise the option in a timely manner?
I think you mean Cass's right to exercise.
Yeah.
So the answer to that question is the agreement does not contain a notice provision, and the court cannot add one in. And then I believe that the way the agreement reads is it's really bilateral, which is Cass can invoke his option right on day one. And in that second half of the term, in theory, Mr. Cass or Mr. Newell could transfer on day one and terminate the agreement. But the issue as it relates to your question, which is the heart of this issue, which is that's the hypothetical, right? Which is what if that happened?
Right.
And
Newell was never prohibited from transferring his interest according to the option agreement.
that's my view.
Right.
But to answer Judge Lindley's question directly, that the problem with Cass's argument is that he didn't timely invoke his rights.
So that didn't happen, but it would have been permissible. Newell could have transferred to his wife day one, and then there's no more option for Cass.
That's how I read the agreement.
Right. So and the agreement is written very unfairly to Cass, but that factual scenario did not take place. Cass had plenty of time, a couple of years before Newell transferred to his wife.
That's exactly. And
But Newell only transferred 50%.
correct.
Couldn't Cass have exercised the option on the other 50?
Well, and of course he have, yes. And again, it goes back to he didn't timely do it.
Right. But my point is that the trial court seemed to say that the preemptive transfer from Newell to his wife defeated Cass's options rights. But Newell still had 50% in his pocket.
Correct.
Couldn't Cash have gotten his option for 50% from Newell, what he had left?
If he timely invoked?
Yes, right.
Okay, so if he timely invoked, I guess that would be a different argument, right? Which would then be he now is trying.
Newell didn't give away 100%.
Correct. And
He still had 50% that Cash could have sought to recoup.
he could have, yep, and he didn't. And really, this is as a timeliness issue, and the breach cannot occur in a vacuum. And so, assuming there was a breach, he still needed to exercise timely. I don't believe there was a breach because there's that other provision that says that Mr. Newell is allowed to divest his interest, and the term expires then.
Right, and under your argument, it really doesn't matter the scenario that Justice Lynn is like that. I mean, it doesn't matter that 50% or 10% or 0%. I mean, the option may have been inartfully drawn, but it is what it is. And you're saying the courts we can't insert language in the
Correct. That's exactly right, which is the agreement is unambiguous.
Right.
And
It's very unfair, but it's not unambiguous.
exactly.
Parties Cass, I don't know if he had a lawyer for this or what, but this was not,
Cass's lawyer drafted it.
geez, well, yeah, it was very pro Newell.
And we don't believe the agreement is unambiguous, and we think the court erred. So I'll answer unless the court has any other questions. Thank you.
Thank you.
Good morning, Jacob Freza on behalf of plaintiff respondent David Cass, and if it may please the court. Just to respond to a couple of co-counsel's arguments here, we do dispute that this was exercised in a timely manner. Counsel is trying to kind of separate the disjunctive and the term. There is
It looks like from the that last paragraph, that the parties contemplated the possibility that Newell wouldn't have 100% ownership of the LLC as of December 31st, 2020. That was possible. They contemplated it because they included that language in there. So if they contemplated it, then the fact that it didn't exist, that's what made the deadline a firm deadline, right?
I would say that this particular provision is ambiguous. And important to consider here is that these two individuals have been doing business together for about 20 years at this point, give or take 15 to 20 years at this point. So there's a lot of things when you have that long-standing business relationship. It was a pre-existing understanding, and things don't need to be said. Things are left unsaid. And it's also important to note that this contract was drafted by the shared attorney by the LLC. They didn't have separate, this wasn't the traditional arm's length transaction where you have two opposing, maybe that's not necessarily opposing, but two kind of adversarial parties.
But there's an argument perhaps that you say, well, you frustrated my ability to exercise my option. That's a claim. In fact, that might be the claim. But you have to exercise it though. I mean, in time, because if Newell were to take steps that could theoretically frustrate the ability to exercise the option, Newell's doing that at his peril. But come that deadline, come December 31st of 2020, then what does it matter?
So our response to that, Your Honor, would be that he was never notified of this. That's the primary issue here, is he was never notified. There's two indefinite terms.
Itself, sorry, we have the same point.
Same question.
The contract itself is notification. It says you have until this time. Does somebody have to wave a flag?
Well, it was at December 31st, 2020, or so long as he maintained 100% interest.
Which could have been sooner.
which could have been sooner.
Newell could have.
I don't think it could have been sooner.
Day after the agreement was signed, this option was signed, Newell could have transferred, say, 1% to his wife. And then that extinguishes Cass's option, right?
I wouldn't agree with that, Your Honor. I believe that the option, as the term is written, would have to leave it open at least until December 31st, 2020.
That's not what it says.
And then also in addition to that, also for an extended term, indefinite term.
But there were rules about the extension as well. You know, like it can be extended, but you got to pay something, $100 or $1,000, whatever it was. I mean, it was really, wasn't it on your clients to say, hey, I'm still interested. Here's my $1,000. I want this for another year. I'm getting my ducks in a row and want to get back in.
What I think what have the issue is here, we're at this without any benefit of discovery. No discovery responses have been provided. We sent some discovery demands. Obviously, this was ongoing, so we haven't pushed for them. But there's a lot of, you're pinpointing a lot of kind of confusing clauses as they interact with one another. I think in the context of the longstanding business arrangement, we're talking about extrinsic evidence we need to obtain to help clarify this arrangement. That's why there's a lot of these, you know, which terms mean what, when, where, what happens. These are the inherent ambiguities in how the contract.
We only get to extrinsic evidence if the agreement's ambiguous. But look, I agree, based on my limited knowledge reading this record inside out, your client was treated unfairly. It seems like he got taken advantage of. This contract was drawn not to his favor, but the contract's not unenforceable, and we have to look at the terms and conditions of the contract, unfair though they may be, and make a ruling based on that.
Well, I would direct the court after arguments are done to Mr. Cass's affidavit, and I think it provides a very rational interpretation.
I read that, yeah.
And complete contrast to plaintiff's interpretation.
Right, his view was, I'm just taking my name off so you can get the first Niagara mortgage, you get better interest rates, and then we're going to transfer it all back.
Yes, sir.
But the agreement that he signed, the option agreement, is what it is.
Right, and we would just, I don't want to be a broken record here, Your Honor, and I understand your point. It's just, there's a lot of ambiguity. So there's the indefinite date, and then there's the firm date, and then there's also the indefinite commencement. So how is he supposed to know to go and ask for it if he doesn't know that he's gotten this mortgage?
Bottom line is, you want some discovery, you want depositions, and then you come back on a summary judgment, maybe.
Potentially, yes, Your Honor. Yes, Your Honor. And I think you've read Mr. Cass's affidavit. You've read defendant's affidavit. I think we have two very rational interpretations of this agreement. Definitionally, and this court's decision
as to who put how much money in. There's all sorts of factual disputes. I'm not, the question is whether they're material or not.
I would say they are. I'd say just how to interpret this contract is the primary issue of fact. And I don't think we can resolve that on this record. Just how this document is written. We can't look at it and say this is 100% what these parties intended to do. And when there's two reasonable interpretations, this court decided in 2009, Nancy Rose Stormer, PC v. County of Oneida, 6683rd 1449. When there's two rational and reasonable interpretations, it's an ambiguous contract. We need extrinsic evidence. Can't do that without discovery. Fundamentally, this motion, the summary judgment motion was premature. The motion to dismiss, the contract itself doesn't inherently provide them a defense. And I would just point out, in addition to the disagreement over the contract, Mr. Cass also vehemently denies any intent to part ways with Mr. Newell. That's a fundamental issue of fact. Mr. Cass insists that the option agreement was entered into willingly by both parties. There was a mutual understanding reached beforehand. This was a simply memorialization that there would be a temporary hiatus, and then they would return to business as usual after the fact. This is particularly important, I think, when we look at the assignment. The consideration was $10. We're talking about two highly valuable properties in Mayville on the lake. Properties and businesses. $10 is obviously not proper consideration for that transfer. The option agreement itself was the transfer, was the consideration.
Well, they say the consideration was getting your client's name off the financial obligations.
I missed that. I'm sorry, Your Honor.
The other side says the consideration for the assignment was freeing your client from the mortgage obligations.
And I would disagree with that, Your Honor, and Mr. Cass disputes that. His perspective is that they had contributed financially and labor-wise 50-50. So he didn't want to walk away from this. I think particularly in Mr. Cass' affidavit, he talks about paying extensive labor costs for renovating both of these hotels.
Right. Well, I think we got the argument laid out in your brief, so we appreciate your argument today.
Thank you, Your Honor.
Case number 206. In the matter of Jessica Fanning versus Joseph Chapman. Mr. Greenberg, good morning.
Good morning.
The appellant has submitted. It's our understanding that there may be a subsequent order that could render this appeal moot. Is that your understanding?
Yeah, so in the first instance, there was an October 25 Monroe County order that varied the terms here, including changing terms regarding visitation, having take place in Rochester, et cetera, et cetera. It seems like there's no way to unwind, even if the court had an interest in reversing the order that's in front of them. It seems there's no way to do that without this interconnection with this later order that's happened.
And that was on consent.
Pardon me?
That was on consent.
That was a consent order. Yes.
You're
So-
the AFC on this?
Yes, appellate. Yeah, not
Are
trial.
you the involved below in this new
No.
consent order?
I was not.
Okay.
No.
All right. Well, I think I can't think of why this appeal isn't moot. Do you have any? Thoughts on-
No,
thoughts?
it certainly seems to be. I think that's the way to resolve it. You know, I also think I will just say one thing in terms of the substance, in case the court had some concerns about that, which is you get some tough relocation cases up here. I know that. This is not one of them. Nothing changed, just nothing changed for anyone in terms of this.
This
You
is
move
Buffalo
from
to Syracuse, or this is Rochester to Syracuse?
Rochester to Syracuse. The mother was going to do all the transportation, and the evidence was very clear with Dad's admission. He barely saw the kids outside of the visitation times anyways, and those did not change. So
We appreciate you coming in.
thank you very much.
Case number 207. It's a matter of Dmitry Galitzki versus another Galitzki. Galitzki versus Galitzki, we'll call it.
Good morning. May it
Good
please,
morning.
good morning. Good morning. May it please the court, Sabrina Bremer on behalf of Svetlana Galitzki. Unless this court has any questions about the legal sufficiency issue, I will rely on the briefing in this matter.
Thank you.
Thank you.
Honors.
Good
Thank you
morning,
for
sir.
listening to the case. I'd like to point insufficiencies in the briefs that were submitted. It stated in a submission of fact that Ms. Galitzki filed cross petition against her husband, but later,
Speak up, sir. I can't really.
my apologies. It stated that Ms. Galitzki filed cross petition against her husband, but later withdrew the petition with the understanding that she would pursue the claims in matrimonial court. That's a statement of fact that were presented by appellant. At the same time, when I submitted it, it is clear that petition was not withdrawn, but it was dismissed and dismissed with prejudice.
Well, correct me if I'm wrong, but the issue on appeal, you filed a petition against your then wife,
Yes,
a family offense petition,
correct,
alleging that she harassed you
correct,
with a course of conduct over time.
correct,
One was taking off the Ring camera while you were in Florida. Other instances. The trial court, the family court agreed with you and granted you an order of protection.
correct.
The order of protection expires soon.
It's already expired.
It's
Yeah,
already expired. That's right, last May.
correct,
You still want this finding of a family offense petition on your wife's record. And that's why you're here today.
correct.
So the question is, was the evidence sufficient at the hearing to establish that she engaged in a course of conduct, not just a single isolated incident, but course of conduct designed to harass and annoy you.
More than that.
All right, so what did she do to harass and annoy you over a period of time?
Over a period of time that, as I submitted in my findings, the key evidence that she planned an action when sheriff showed up at the house with long guns drawn, and she called police that she saw me on a yard with a assault rifle walking. Sheriffs came in. It was very well calculated move on her part. And reason I believe it was calculated move because she presented a picture of that air gun. It was air gun that was allowed to be kept in the house.
So you were outside with an air gun?
No. Air gun was secured in the house.
Okay.
Air gun was allowed by police, by sheriffs, Your Honor, to be kept. I surrendered all my firearms as I was directed.
So she called the police and lied and said you had a
Correct.
gun.
I was
You did.
walking on. She was found not fully credible in her testimony.
Okay.
She claimed that she spoke Russian to the dispatcher when she made 911 call. We have a recording of it. I can produce it. She spoke English. Further, she produced a picture of that air rifle during the hearing, which indicates that she knew about it and did not report it right away. Her concern was for the safety of children. And she discovered that there is a left behind a firearm in the house while I was removed. I was wrongly removed. I should not have been removed from the house. Sheriffs misread the petition. The judge's order was do not harass order. It was not stay away order. So I was removed wrongly. So I had every right to be in a house. On advice of my attorney, I went to the sheriff's office and I presented those evidences and I said my intention to be in the house. I will be in the house. I have every right to be there. So she had a picture of it and she did not present that to police when she discovered it. She waited for me to return because she understood the order was not the stay away order, but she installed her Ring camera to see it. I had a $2 million policy on my life. She was primary beneficiary of it. God forbid if that would happen. Those sheriffs came in not to tase me. They did not come. All I had in my hands when I was handcuffed and put on the ground, toilet paper. I had a real ream of toilet paper, nothing else.
All right, well, I'm looking at your petition that you filed. And I don't see anything about this air gun, this incident when the police came. Your allegations were that in January 2024, she got mad at you and said to you, I want somebody to beat you up.
That was those additional thing happened after the original petition.
Okay. And then on another date, May 5th of 2024, you were in Florida on vacation and you received an alert from the Ring security camera and you realized she disabled the camera. And you say that harassed you, even though you're 1,300 miles away. That was number two. Number three was on May 16th, you asked her for her EBT card.
Correct.
To get food. Government paid for food. She got mad at you and refused to give you the card. That's another instance of harassment. So those are the three, and all of those combined equal harassment. That's what the petition says. Now you're going into other non-alleged in the petition instances. But I think we're limited to what you pled.
There were additional violations that had to be filed.
Okay.
Which I, on advice of my counsel, filed, and they were all heard during that case.
So what do you, I mean, we don't have a whole lot of time, but you got the incident where she said you had an assault rifle and you didn't.
Correct.
She disabled the Ring camera.
Yes.
She forcefully tossed her EBT card at you. and what she said, I want somebody to beat you up.
In addition, she was hitting me with the bathroom door on September 13th.
Say that again,
I'm sorry?
I didn't hear what you said. She was hit with a bat?
Bathroom door.
Bathroom door, okay.
That was on the September 18th, she disabled cameras in my office, which were allowed to be kept in my office by Judge Lynn.
You don't live with her anymore, right?
No, correct.
You're
We are divorced completely.
Okay, so why are you, the order of protections expire, why are you still fighting? Why are you here now? I mean, it's your right, don't get me wrong, but I don't get why you're so vested in this now.
I was saying that my testimony was wrong, and I'm here to defend that my testimony was
Okay.
correct.
Well, you want to clear your name.
Correct. And plus, the argument that was presented in finding of facts by appellant attorney is false.
Okay.
She did not withdraw her petition. Her case was heard, and her case was dismissed with prejudice.
You guys getting along now?
No.
Didn't think.
I'm trying. We have 3 children together. You know, we have custody of a small one. Beautiful child. She's a wonderful mother. But we did not get along, and I think that I don't believe she did it. I do believe that she, at some point, wanted to have that $2 million policy. And that would have been
life insurance policy?
correct.
He wanted you dead?
Correct. Not by her own arms, but it was well-calculated plan.
She's gonna hire a hitman?
No, she called the police. If she was concerned about the safety of children and that there's a gun that she found in the house that I failed to surrender, first action would have been call 911, let them come to the house, confiscate the gun. Not just take a picture of it that you can present later.
She was hoping the police would shoot you.
Correct. That I would do something irrational. Not that I would, but I have a deep respect for our forces. I'm a volunteer fireman myself. But point is, she knew about that policy, and when divorce is over, she knew I would take her on.
We're gonna take a look at everything. You wrote a brief here. The most encouraging thing I heard you say all day was that your ex-wife is a wonderful mother and that you love your child. So there's some, we hope that you spend a little more time thinking about that than some other matters, but we will give you a ruling. You're entitled to an order here on this appeal. So we will give you that.
Thank you, Your Honor.
Thank you. Case number 208 is Broadway Warehouse Company versus Buffalo Barn LLC. Case 208. We are back. I think this is round 6. Is it round 5 or 6? I've lost count.
We've been here before. Yes, Your Honor. Good morning, Your Honors. J. Michael Lennon. I'm from Roach, Lennon and Brown on behalf of the appellant. Although this case does have a lengthy history, we're here today really on 2 discrete issues. And the first is whether my client was entitled to costs and expenses, including reasonable attorney's fees, to prosecute this case.
Like fees on fees, as they call it.
Well, I understand that that's how the court below characterized it. And I think that I would take a step back and say, when you look at paragraph 18D of the lease, it clearly states that my client as lessor is entitled to all costs and expenses, including reasonable attorney fees, incurred to obtain judgment. And the judgment that the trial court granted in March of 2025 was the first and only judgment that my client had against Buffalo Barn Board. So our initial argument is these were costs and expenses, including reasonable attorney fees, incurred to obtain that judgment.
Right. So just so we can go through the facts, make sure, I've been here on a number of these, but
Yes, Your Honor.
the underlying claim was failure to pay rent for a warehouse in Cheektowaga.
Correct.
Your clients rented it to the tenant.
Correct.
The tenant left the premises with the security, which was lumber, owing about $71,000.
That's correct, Your Honor.
So it started out with a breach of contract, you owe me for the rent, plus the attorney's fees to collect it. It took a while, but your client finally got that paid in full, plus interest, $118,000 plus in December of 2017. So they got the unpaid rent and they got interest. Now, that wasn't enough though, because you wanted attorney's fees, which is not unreasonable.
Yes, Your Honor.
To everybody and their brothers and sisters to try to collect that 118. And now you've gotten here, you've gotten $135,000 in this case for the fees that took you to collect the 118.
That's correct, Your Honor.
That's not what you want.
That's what
You
the
want
referee, I'm sorry, Your Honor.
You want like another $300,000.
No, Your Honor, in terms of what we're seeking on this appeal, the referee did, you're absolutely correct. The referee's recommendation to the trial court was $135,000. And that included approximately $45,000 in fees for the prosecution of this case. And this case goes back to the original case, the 2012 case, as I know this court is aware.
Right, so yeah, I misspoke. The judge gave you $88,000.
Yes, the judge pulled the fees to prosecute this case out of the equation, and it's our position that they should have stayed in because of the clear language of paragraph 18D. Whether you look at it as, are these fees incurred to obtain a judgment? We believe they were. But even if you say, look, these are fees on fees, as respondent said, they're being cute. Even if you say, look, these are fees on fees, and that's generally not something you can recover. When you look at the case law, it says if there's specific language in the contract, and we believe that paragraph 18D couldn't be clearer.
I read that, so I think we're on the same page that to get attorney's fees, to collect attorney's fees, it's possible if there's a statute, which we don't have.
Right.
Or if there's a contractual provision that says you can collect attorney's fees on legal work incurred to collect attorney's fees. You're relying on a standard form attorney's fees provision in a landlord-tenant agreement. That doesn't, if, maybe I'm wrong, but that just seems like a run-of-the-mill attorney's fees provision. And if that's the case, everyone can get fees on fees.
Well, Your Honor, I think it's more than that. It's not just simply the phrase reasonable attorney's fees. When you look at the clause and you read it as a whole, it says all costs and expenses, including reasonable attorney fees, incurred to obtain judgment, collect rent, utilities, damages, or other amounts due. So it's broader than most. But when you compare it to the situations where courts in the past have said, whether it be a statute or a contract, yes, fees on fees are permitted. In those cases, and we cite them in our brief, the phraseologies that's used is often reasonable attorney's fees. So I think it's situation specific. And when you look at the language here, again, it's our position that language couldn't be clearer, that it permits what is allowed if this court decides that what we're pursuing are fees on fees and doesn't just say, oh, that's it, because we are correct. This was pursuit of a judgment against Buffalo Barn Board, which we never had for a variety of reasons that are, explained in the record. And the respondent uses the analogy of, well, what if you got an Uber from downtown Buffalo and wanted to go to the airport? Should you have to pay if they take you to Rochester and Batavia? I don't think that analogy holds up because the route that my client had to take here was driven in part by the actions of the respondent who, number one, didn't pay the rent. Number two, removed all of their inventory, which we had a security interest in. Number three, the principal filed a fraudulent bankruptcy, which my client had to fight, et cetera.
Yeah, so you make a lot of good points, but on the other hand, there were legal actions that your client commenced that we here determined had no merit and we dismissed them. For example, against Attorney Palsgraf. There were some lawsuits that were deemed to have no merit, and that's what they're talking about, I think there. But
well, I don't want to argue with the court about its decisions, but I don't think it was that clear cut. Those cases were still alive until after that, about 5 years of litigating. They were alive until the
principal paid the judgment on his guarantee. And at that point, this court said, look, if you're entitled to attorney's fees and that's all that's left, you can't collect it from these other folks because you don't have a contract with them and there's no statute. That's what left us with our focus on Buffalo Barn Board, which is what brings us here today.
So your total request that you wanted before the referee, plus prejudgment interest, you wanted $480,146.08.
I believe that's the total of fees, and the invoices that back it up are all in there.
The underlying claim was a $70,000 failure to pay rent.
That's correct, Your Honor, but I think
$500,000 to chase 70.
but the decisions were, I think you have to look in a vacuum. I understand that sounds absurd, but when you look at these cases, and that's why we lay out the history, there were decisions that were made. This wasn't, we're going to spend however much it takes to recover. There were decisions that were made in attempts to collect this rent. And yes, this case has taken on a life of its own, but that is not all or even at all my client's fault. My client has a contract with terms that were agreed to and reaffirmed, I should add, 3 times when this lease was extended 3 times. All terms were reaffirmed that specifically allows for them to collect attorney's fees. And they were aware of that clause and they kept that clause in mind as they pursued these remedies.
You want to be heard on prejudgment interest real quick?
Yeah, sure, Your Honor. Thank you. So with respect to the issue of prejudgment interest, this is a breach of contract cause of action. I don't think there's any dispute about that. We were granted summary judgment by the trial court on liability for that breach of contract action. As I read the CPLR, prejudgment interest is mandatory. It says that interest shall be recovered on a sum awarded. And so therefore, it's error for the court not to have found or allowed for prejudgment interest.
Can I issue this? The referee in the report filed in December 2024 did not grant you prejudgment interest.
Correct.
You file objections to that, to the report, but not to the failure to give prejudgment interest. Is that a waiver of that claim? Do you need to preserve it because you objected to the other portions of it? Referee said no prejudgment interest. Your objections didn't say anything about an error not giving prejudgment interest.
Well, I actually, Your Honor, when the original motion to object to the report was filed by the respondent, and they objected to the entirety of the report. We cross-moved pursuant to CPLR 2214, and in our cross motion, we objected to the 2 things that we're here on today. But prejudgment interest was part of our objections. Yes, Your Honor.
Sure.
Yes, and in appellant's cross motion, prejudgment interest was one of the issues, and
I'll take a look. I could be wrong.
And the basis for it was that the referee did identify specific timeframes where the fees that she awarded, and she did a heck of a job, I think, really wading through all of this and looking at all these invoices. She, in 228 of the record, she has a chart where she identified the dates that these fees were incurred. Those are the dates for which interest for that particular element of the damages would be calculated.
I was under the impression that the judge said that I didn't ask you to do that. I didn't ask you to go beyond the date, beyond 2019, I think it was.
That is what the judge said in the decision that we're appealing, but it's our position that that's inconsistent with the summary judgment order that she entered in 2024 and the instructions that she provided to the court. She reinterpreted her own instructions to the referee, and our position is that the referee's interpretation of those instructions was correct.
Thank you, counsel.
Thank you, Your Honor.
Morning, may it please the court, Justin White on behalf of the respondent. To address the last issue that came up on prejudgment interest, the case law that we've cited in our brief goes to the issue of prejudgment interest on an award of attorney's fees. In both cases, do not support the imposition of prejudgment interest on an attorney fee award.
But it hasn't been set yet.
Pardon me?
The amount of reasonable attorney's fees hasn't been set.
It has not been answered.
You don't award prejudgment interest on an undetermined amount. I mean, how much would you pay? That's your argument.
That's our position in a nutshell. And we also noted that in the appellant's brief, there was no such support or contrary support to what we had advanced as the law on attorney's fees and prejudgment interest. Secondly, the question has come up, well, how far should the referee have gone, and did the referee go too far, and did the court make error or commit error in scaling back the referee's decision, particularly this question of fees on fees? Well, we believe that the lease provision 18D is a vanilla clause awarding a landlord or a tenant reasonable attorney's fees. It does not contain the specific, unmistaked language that's necessary under the case law. In fact, case law supports the notion that there should be an unequivocal declaration of entitlement to attorney's fees or collecting attorney's fees, and if there isn't one, then you don't get them.
If this, in your view, if this clause in this lease authorizes collection of fees on fees, every landlord that has a standard attorney's fees clause could get fees on fees.
That's how it plays out, and it's not a policy.
Nothing unusual about this attorney's fees clause.
No, nothing that was necessary to be in the attorney's fees clause to justify their request. And then, you have to look at the backdrop of the whole case. I mean, here we are. They were satisfied completely in 2017 on December 5th when Mr. Anderson brought in $118,000. That was the hard stop that the court gave to attorney's fees. That was the hard stop that the appellant himself had asked, or itself had asked for attorney's fees the period between 2010 and 2017. So to go beyond that 3 times is a bad decision, and it can't be supported.
They've gotten more in fees than they were owed in rent.
Well, that's the bleak house comment. I guess that's where the bleak house comment comes in that I made at the beginning of my brief. How far back are we going to go? How far along are we going to travel before this thing stops? I mean, does Dracula belongs back in his coffin?
I can't answer that question.
Pardon me?
I don't know the answer to that question. I'm not sure how it's relevant, but anything further on your argument?
I meant to imply, Judge, that, once the 2017 payment of all the amounts due and the interest due was completed, that's the end of the trail. And this artificial new case causing or claiming that not paying attorney's fees is a breach was itself
Your more specific argument is that this clause needed to say specifically that they were entitled to attorney's fees, including the collection thereof. That clause is missing. So isn't that the essence of your argument?
That is the essence of my argument.
Thank you, Counselor.
Thank you.
Case number 209 is entitled In the Matter of HSBC Bank USA N.A. versus Gracia M. Campbell. Mr. Markarian is in court with us. We are waiting for appellant's counsel virtually.
Okay.
Is Mr. Consulik in the waiting room? There he is. Okay. Counselor, you may proceed for the appellant.
Thank you, Your Honors. Good morning. Okay, I'm going to read this because it's kind of complex. The lower court has unnecessarily interpreted the trust to identify the generational root for per stirpes distributions. MKC, the grantor, intended for herself to be recognized as the common ancestor for these distributions. Therefore, her closest surviving descendants at the termination of the trust should be considered the generational root for the distributions. Caption, legal basis for per stirpes distributions. Per stirpes distributions are given to the generation closest to the common ancestor as per EPTL 1-2-.14 and related case law. In this, if, for instance, Gracia, who is one of MKC's daughters, was alive when the trust ended, then MKC would serve as the shared common answer in line with MKC's instruction that her surviving children each receive an equal per stirpe share of the trust remainder. Deceased siblings do not qualify as ancestor. Only MKC as the deceased parent fulfills the criteria for a common ancestor according to the express language of the trust. Caption, evidence of grantor's intent, child versus issue. MKC's use of children rather than issue for per stirpes distribution indicates her intent to be seen as the common ancestor. If MKC had opted for the term issue, as suggested by the respondents, it might have created ambiguity regarding the common ancestor for the per stirpes distribution, particularly concerning a minority of court decisions that existed at the time the trust was created in 1934. Nevertheless, even if MKC had used issue instead of children, the per stirpes distribution would still trace back to MKC as the common ancestor. Caption, align with case law. This view is consistent with the case law at the time, such as the 1932 case of Matter of Foster, which authorized equal per stirpes distributions to surviving grandchildren at the termination of the trust. Respondents' interpretation. Respondents reference for the first time.
Counsel, are you reading from your brief?
No, I'm reading from my notes of an oral argument.
Okay. Anyway, you can just have a dialogue with us because it's kind of hard to follow.
Oh, it is? Okay, I thought it might be, but I just also.
Yeah, let me,
in my opinion.
I agree. And so thank you, Pastor. I think your argument in a nutshell is that the per stirpes, we look at the generational level where there are survivors. If, for example, with the children of the grantor, 3 children, the life of the trust, there were 2 measuring lines. Let's say the youngest one, Gracia, GMC, you call her.
Right.
If she were alive,
right,
and the other 2 died, then the trust terminates.
Right.
Then it would be per stirpes for the 3 children, right?
Per stirpes calculated at measured from the level of the grandmother. It has to
so Gracia would get a third.
That's right.
Hazard's 3 kids would get a third of a third, and Marjorie's 2 kids would get equal half of 1/3, whatever that may be. But crucial to this case factually is Gracia died first.
Yes.
She died. She was not the third one to die, even though she was the youngest. So when the trust terminated, there were no children left of the grantor. So then we look, in your view, per stirpes goes to the grandchildren. There's 10 of them, and they all get 1/10. That's what
right.
should happen here.
That's right.
And your further argument is that that's what the EPTL calls for, correct?
That's what the EPTL calls for, and that's what the majority of case law called for. That method of distribution when the trust was created, and so that's the method of distribution in this situation in New York State.
Right. That was codified in EPTL 1-2-1.14. right? That's what you're arguing.
That's right, but also because EPTL one, the one you just quoted, only came into effect in I think 1990. So I have to say, even that principle that's codified in that section of the EPTL is basically a codification of cases such as matter of Foster, which was affirmed by the Court of Appeals. And so
they're
that's
just trying to clarify with the amendment. They were trying to clarify that which was a little unsettled, and they finally did it. But it is, Justice Greenwood, you agree with him that your interpretation is consistent with the new EPTL. I think it's 1.2 -14.
That's right. It is consistent with it. It is consistent with it. And this court in matter of Fusel actually reaffirmed this entire method of distribution. And this method of distribution is, which New York started prior to this case being created, is now called the modern per stirpes. New York, always being on the cutting edge of the law, was doing it back in the 1930s. And this court reaffirmed it in its case of matter of Fusel. The same situation. The only difference is that the common answer in Fusel was a niece and not a direct descendant. She was a collateral descendant. But in this case, Marjorie Klopp is going to be considered, the common ancestor. In this case, Marjorie Klopp is the common ancestor. She's both the grantor and the common ancestor, and it has to come that way because there has to be because that's the only way that it's confirmed, because that's the only way that she would have provided for her children to receive per stirpes distribution. There had to be a common ancestor, and that would have had to have been Marjorie Klopp. And so Marjorie Klopp was the common ancestor all the way along. And just like in Fusel, the grandchildren wind up being the stock because all of the children were predeceased. So each of the
Fussell was written, an opinion written by the former presiding justice here, Hank Scudder, who was a surrogate earlier in his career, and he was on a lot of these commissions. And his decision, his opinion there is still good law. We understand you're relying on that. Anything else you want to add before your time expires?
I don't think so. I just want very quickly want to just check, just to remind the court, which I'm sure it's aware of, is the equality of distribution and the matter of Rice case, where it was a similar situation, 15 grandchildren, and the court ruled there that the grandchildren would each share because all of the children were dead, so the grandchildren each got 1/15. So that's it. That's the core of our argument. Yes.
All right. Thank you. We'll turn it over to Mr. Markarian.
Okay. Thank you.
Thank you.
Good morning, Your Honors. May it please the court. Ed Markarian for respondents Sharon Douglas and Marjorie Dillon. Your Honors, a per stirpes distribution is to persons who take as issue of a deceased ancestor. That deceased ancestor is the head of stock. So we have to identify the head of stock. And the trust says to issue of any deceased child. Any deceased child is the head of stock. It's explicit in the trust instrument. So that's the head of stock, and each stock of the head takes their respective parent's share. So here the children are the head, their children take their parents' share. I think.
Doesn't the trust itself sort of change our focus by determining the death upon which we measure the distribution of the trust? It sort of readjusts the whole idea of what's the first line of distribution?
No, Your Honor. So that was, I think, some of the discussion earlier, I think, fails to draw the distinction between a direct gift and a per stirpes gift. So if Gracia were alive, she would not take as issue. She would take as a child. That's a direct gift. So that has nothing.
Yes.
She would get a third.
She would get a third.
Right.
And then
but her children wouldn't get anything.
Correct. But
the other two, if they were dead, their grandchildren get per stirpes.
Correct. They would take their parent share. And it doesn't change whether Gracia is alive or not. The fact that Gracia is there, she doesn't take per stirpes. She takes a direct gift. So when we're talking about per stirpes, And I think it's helpful here, Your Honors, to actually hold up the language of the trust right next to the statute, 1-2.14, because it's remarkable how the language of the trust follows the statute. The trust language is to issue of any deceased child in equal shares per stirpes. 1-2.4 is you take as issue of a deceased ancestor. So the statute is deceased child. The trust is as a deceased child, any deceased child, singular. The statute is issue of a deceased ancestor. The difference is the word child versus ancestor, and the child is the ancestor here. That's the head of stock. And so each grandchild of the respective parent take their parent's share. That's what this says. And when you compare the language of the trust with the language of the statute, it tracks.
What do you make of the Fussell case that opposing counsel
Yes,
advised on?
Fussell is absolutely great law. And I agree that presiding Justice Scudder analyzed it perfectly. And that shows what the grantor did not do here. So it's to a niece, but I think it's easier to understand that the head in Fussell was the grandmother. And the issue presented was what happens if there are no children of the grandmother, only grandchildren. And the language in Fussell is not the language here. The language in Fussell is to the grandmother's issue per stirpes, not to the grandmother's child or the issue of a deceased child. It's to the grandmother's issue. So when you take as issue under the statute, you take through the person. And in that case, you're taking through the grandmother and you're all at the same level. So you look to the level where there's the closest member to the head of stock. So if the grandmother is the head of stock and there are only grandchildren, the closest level is at the level of the grandchildren. If the child is alive and they're the head of stock, the closest level is the level of their children. So each child takes their parent's share if the child is the head of stock and not the grandparent.
Can we just go through the language of this trust? It says, the trust hereby created shall cease to terminate, and the trustee shall thereupon transfer and deliver the property, then constituting a trust fund, unto the then surviving children or child or children of the grantor.
Right.
They're all dead.
Right.
So that's not possible.
Correct.
So we can kind of cross that out.
Yes.
Right. So then we'll act like it doesn't exist, that little phrase. And then it continues, and the lawful issue then surviving of any deceased child or children of hers, of the grantor,
right,
in equal shares per stirpes and not per capita.
Right.
So if we just focus on that phrase,
Yes.
because none of the children are alive,
Right.
the lawful issue of the then surviving deceased, doesn't that mean that each grandchildren gets it per stirpes?
No, it'd
Why
be,
not?
yes, they get a per stirpes, but per stirpes from whom?
Yes, well,
Not from-
it's what generational level do you start
Yes.
per stirpes? Do you go
Correct.
with the deceased children or the first line where there's a live person?
No, you go to the first line where there's a member of the class closest to the head of stock. So you
Alive
have-
or dead?
Alive, from the head of stock. So you have to identify the head of stock. And Fusel, the head of stock, was the grandparent because it said to the grandparents issue per stirpes. She was the head of stock. The grandchildren were the closest. In this case, it's to the issue then surviving of any deceased child, of a child. Issue of a child makes the children, respectively, each child, the head of stock. And I don't think it's irrelevant that prior language about Gracia being alive. It shows that the grantor, in the same sentence, in one single sentence, she's trying to cover everything. And she's addressing the possibility of Gracia or afterborns being alive. And she's saying if they're alive, they get a full share directly, not as issue, as a direct gift. And so the focus, because the key is trust maker intent, the focus is what did the trust maker intend here?
Do you think this could have been drafted a little more clearly? So we and
Always.
I mean,
Yes, but I don't think it's hard because again, if you hold this language up right next to the statute, it tracks the statute. Even though the statute didn't exist then, it codified existing law. You'll see it tracks a statute. Issue of surviving of any deceased child is a trust. The statute is who take as issue of a deceased ancestor. child is the ancestor. That's the only different word.
So if the language of any deceased child or children of hers, if that language had been left out, hypothetically, then you would suggest, well, then that's the first piece to the grandchildren. That's what that would mean.
Right. I would think if she did that, and the easiest thing for the grantor to do here was the fusel situation. And that would you really have two choices here. You say, I leave it, the grantor, I'm the grantor, I leave it to my issue per stirpes, which is fusel, or I leave it to my children and their issue per stirpes, which is this case. You're making the children the division point and not just saying to the grantor's issue, which would be the easiest thing to say, and it's not what they said here. So I also think it's relevant, Your Honors, that, trust maker intent is key. She was 34 years old when she made the trust. She didn't have grandchildren. She had a 6-year-old, a 4-year-old, and a 1-year-old. She's focusing on her children. Her words say that she's making them the heads of stock.
The possible purpose of measuring life just 2 and not the 3. What
could you? I apologize.
She said that the measuring life of the trust,
right,
is the life of her first 2 children, not the 3rd.
Correct.
What is
what's
the rationale for that?
I don't know, but she also said the same thing for afterborns. So there were 2 that were measuring lives. The middle child was not a measuring life, and afterborns, which were possible, she was only 34, were not measuring lives. I don't know, but what she did do is say the children take, an issue of children take, showing that the children are the heads of stock. And it's just in case it crosses anyone's mind, and I apologize if I'm taking too much time, but always with these, there's a question of fairness. So I just want to give you some of my thoughts on that. This comes up every time we draft a will or a trust for a client. I sit down and I ask them this question. If there's a tragedy, if your kids aren't alive, what do you want to happen? And I draw a little picture for them. And I said, do you want to equalize it at the level of your children or at the level of your grandchildren? And some of my clients will say, you know what, if my son has 1 child and my daughter has 2 children, my daughter's team shouldn't get twice as much as my son's team. I want to equalize it at the level of my children. And some of my clients say that if none of my children are alive, it's all grandchildren, I want each grandchild to receive an equal share. What's fair is up to the person who is writing the document. And some want to equalize it at the children's level. Some want to equalize it at the grandchildren.
Benefits a family that has a lot more children,
right,
and one benefits a family that has fewer children.
And where do you want equalizing? Fairness is in the eye of the beholder. Some clients want to equalize it at the children's level, some at the grandchildren's levels. This is not a fairness question. It's what did the grantor want? And she said she wanted the children to be heads of stock. So we asked that the court.
Thank you.
Thank you very much.
Case number 210, Hedman Resources Limited versus Occidental Chemical Corporation. Case 210.
May it please the court, Peter D'Annunzio for the appellant, Hedman Resources Limited. This should be a simple and straightforward contribution case. Hedman was sued and took a judgment by the respondent's former employee for claimed asbestos exposure while working at the respondent's North Tonawanda plant. While the respondent was very much negligent in bringing about the employee's injury, respondent was immune from suit by its employee by virtue of the workers' compensation law. In a 2024 decision affirming the judgment, the employee's judgment against Hedman, this court previously held that GOL 15108 apportionment to the respondent in the employee's underlying action against Hedman was unavailable due to the immunity provisions of the workers' compensation law. Thereafter, Hedman satisfied the judgment and sued the respondent employer in contribution. From there, discovery should have proceeded, but for Supreme Court's September 2024 order, which dismissed Hedman's complaint on the quote merits in response to a CPLR 3211 motion. Now, Supreme Court's dismissal order should be reversed as a matter of law for both procedural and substantive reasons. Procedurally, Supreme Court disregarded the controlling legal standard as set forth in the Court of Appeals Rebuttal decision and as interpreted by this court by failing to accept the allegations of the complaint as true and failing to draw inferences in favor of Hedman, the pleader, to determine whether a cause of action existed. Instead, Supreme Court decided the merits of Hedman's claims and engaged in improper fact-finding that Hedman's allegations were, quote, just not true and, quote, falsely stated things. Moreover, Supreme Court further erred by failing to draw all inferences in Hedman's favor, and in fact did the opposite, and drew inferences in favor of the movement, and disregarded both the allegations of the complaint and the evidence before it in doing so. And I think it's important to kind of go through that evidence in the record to illustrate that.
So before you go through a lot of provisions there, aren't some of your claims abandoned here because they're not in the brief?
Our
indemnification.
We are not challenging dismissal of the indemnification claim. So our claim right now is limited to the challenge of dismissal of the contribution claim with prejudice.
So I just wanted to be clear on that. Okay, so we're only talking about contribution here.
That's correct. That's correct.
Okay.
Yes, yes, we are only talking about our cause of action for contribution.
And not the declaratory judgment either. On the indemnification.
I mean, at this point, the judgment's been satisfied, so I don't think we've abandoned the declaratory judgment claim, but I think it's moot in light of the fact that the judgment's been satisfied.
Okay, great.
So if you look at Supreme Court's order, the putative facts that it relies on in finding that Hedman's allegations were just not true are an affirmation of the respondent's counsel. And where the court went wrong in applying the Ravello standard is that Ravello says that you can consider evidence in a motion to dismiss for a limited purpose, at least if you're seeking to dismiss the case. Now, the affirmation of respondent's counsel is not the sort of affirmation that conclusively establishes that no cause of action exists. Instead, it makes factual contentions, which are disputed on the record. Hedman alleged that the settlement in question was collusive. And the Hogan affirmation, which was not on any personal knowledge, it doesn't state that the affirmant was involved in the negotiation of the settlement in question, simply declares that the settlement was for a non-nominal amount.
Counselor, is there a dispute in the record that there was a release?
There's no dispute that a release was signed. We dispute that a claim was released.
You dispute the effect of the release.
We dispute that a claim existed to release. There's a document called a release in the record that was signed.
Right. Okay.
Now, if you look at the Hogan affidavit and the controlling legal standard, this court has said that to be considered documentary evidence, evidence must be unambiguous and of undisputed authenticity. It must essentially be unassailable. And that is not at all what the Hogan affidavit is. It says that the plaintiff released claims, but we know that the underlying employee had no claims to release because they were immune from suit under the workers' compensation law. So the claim itself was illusory. And indeed, this is a court affirming the judgment, cited the workers' compensation law in finding that Hedman was not entitled to equitable apportionment.
What about the grave injury exception to the workers' compensation law? How does that play in here?
So it affects the timing of when Hedman can bring its cause of action for contribution. Hedman can't bring its cause of action for its claim.
There's no claim against your client because of the workers' compensation law, but that's an exception. The grave injury, there would be a right to make a claim for damages in that situation. And certainly we have the underlying plaintiff lost his life.
So there is an underlying section so that a tort defendant can bring a claim for contribution. It is not an exception in favor of the plaintiff at any time. The the respondent always remains immune from suit under the workers' compensation law from the plaintiff. And that's the key difference. Again, and fundamentally what happened here is, yes, there was a release, but we allege that that release was not made in good faith. And that's an allegation that the court overlooked. The court also overlooked our pleading.
And why wasn't it made in good faith? What were the factors there? Was it not really paid? Was it not really owed?
So both, Your Honor. So the employee had no claim in the first instance. We allege the amount of consideration was nominal. The only evidence in the record we submit has to be construed to mean $3, because while the release is in the record, the respondent never submitted the amount that they paid. Now they attempt to latch on to another figure at page 7 of their brief. They talk about approximately $270,000, which is a credit that had been received as the aggregate sum of all of the settling tortfeasors that did not appear on the verdict form. That includes 6 defendants. We do not know how much Occidental contributed towards that $270,000 sum, because Occidental chose not to put that information into the record. So we're left with $3.
That was provided by the plaintiff, that figure.
That figure was provided by the plaintiff, and Hedman did seek disclosure of the details of the settlement in the underlying case. The plaintiff voluntarily identified the fact of settlement, again, belatedly, and Supreme Court required the plaintiff to disclose the date of the settlement.
So you don't believe that non-nominal gets you there, gets them there, with respect to showing that that's enough to show good faith? Oftentimes, with good faith, though, we see that the plaintiff gets something else in the bargain. They get testimony, they get favorable, or now one defendant will now provide them information to pursue another defendant, something like that. I don't even see that allegation there.
So I would direct the court to page 63 of the record, which is paragraphs 69 to 75 of our complaint, where we talk about the plaintiff. The plaintiff got something out of this, although to be clear, a collusive plan does not require both participants in the plan to benefit from it. It only requires some detriment to Hedman, which there clearly was, and it was twofold. First, by misstating that Occidental was not a former party who settled, they persuaded Supreme Court to quash Hedman's subpoena, her trial subpoena, seeking evidence to defend itself at trial. But the other thing that clearly Hedman has suffered a detriment by and respondent has benefited from is that Hedman's contribution claim has been extinguished. And that's the only claim that exists. There is no claim vis-a-vis the plaintiff and the employer. And if Hedman had received any meaningful form of offset under the general obligations law, we would not be here. But they did not, because they did not have the opportunity to seek equitable apportionment during the trial. And on this record, the settlement was $3. That's not a meaningful offset. They're trying to latch on to $278,000, but that requires an inference. And the procedural posture matters here. You know, the standard under Ravello, we submit, requires that you draw that all inferences in favor of Hedman. And they require inferences when they've only said non-nominal to get over that hump. Now, I'd like to also address the Terzaska case, because they argue that Terzaska is sort of dispositive. Terzaska couldn't be more different from this case for many reasons. In the first instance, Terzaska didn't deal with contribution. It dealt with a defendant getting a GOL 5108 offset after an employer had settled. So we know that didn't happen here, because that's reflected in this court's 2024 decision affirming the judgment. Second, unlike the respondent here, the employer in Terzaska disclosed the amount of the settlement that they paid, and it was over $800,000. So there's no question of good faith. There was no question of the sufficiency of the consideration in the Terzaska case. It simply could not be more different than the instant facts. The other thing that's important about Terzaska is that the employer was impled into the underlying litigation, joint issue, and litigated it for 2 years. So you do not have a circumstance that you have here where the respondent was held out of the underlying litigation because of workers' compensation immunity. We submit that Terzaska wasn't limited to its facts and that Tassone is the instructive holding here, where the employer was immune, where under these facts, they paid virtually no consideration for a release a non-existent claim.
We understand. You asked for 15, you're at 18 already, so if you could wrap up.
Thank you, Your Honor.
Thank you. Mr. Glasgow, good morning to you.
Thank you. Excuse me. Thank you, Your Honor. May it please the court. My name is Joshua Glasgow, Phillips Lytle LLP. With me at counsel table is Kevin Hogan. And a small matter of housekeeping. My appearance today is on behalf of the successor to Occidental Chemical Corporation, Environmental Resource Holding LLC. I note for the court under CPLR 1018, the case can proceed under the original caption when such a successor occurs. So we don't think any action is necessary, but I want to note that.
Thank you.
Hedman's contribution claim is barred by GOL 15108 because Occidental settled with the Vigliettas in the prior action. To get around the statute, Hedman has argued that the settlement agreement was made in bad faith. And this court explained in the Torres case that bad faith in this context means that the parties to the settlement agreement acted collusively in exchange for a promise to cooperate improperly. So throughout this litigation, and then even here today, Hedman has not asserted any theory of what improper conduct, what wrongful purpose the parties to the settlement agreement had. Occidental faced a very real threat of liability if Mr. Viglietta passed away prior to verdict. He was terminally ill at the time. That's often the case in asbestos cases. He passed away about 1 month after the verdict. So if he had passed away 1 month earlier, Occidental could have been impleaded and faced liability. That's the reason it settled this case. That's exactly what the statute is intended to support. It's intended to encourage settlements, not to discourage them. So, the arguments about why the settlement was improper appear to focus this morning on the proposition that because Occidental was a former employer of Mr. Viglietta, there's this sort of implicit exception in the statute. I note that there's nothing in the language of the statute that would exclude employer-employee settlements. And in fact, this case has already been decided by this court. In the Terzaska case, this court specifically rejected the theory, quote, "The general obligation law, section 15108, does not apply to a settlement between an injured person and his or her employer." The court held, quote, "Plaintiff's employer is a person liable or claimed to be liable in tort for the same injury within the meaning of general obligation law, section 15108. It held that the prior case that Hedman is relying on, Tassone, to the extent it held otherwise, quote, "is not to be followed." So I think this court has already decided that that primary question of whether there's some exception for employee-employer relationships. I'd also note here that the structure of the statute is sort of a little curious. So subsection B of the statute provides the contribution bar. It says, if you receive a settlement as described in subsection A, you're immune from a contribution claim. Subsection A provides, text exactly right, it refers to a release given to one of two or more persons liable or claimed to be liable in tort for the same injury. Now, I think Hedman is arguing that because the Vigliettas hadn't asserted a formal lawsuit against Occidental, the statute doesn't apply. But the statute doesn't refer to a claim by the plaintiff, right? It's written in the passive voice, claimed to be liable. And if Hedman is not claiming that Occidental is liable for a tort injury to Mr. Viglietta, then I guess we can pack up and go home, right? The entire reason that Hedman filed this case is because they're claiming that Occidental is liable because it committed a tort against Mr. Viglietta. That's the basis of its claim. So we think clearly the statute applies, and really that's never been disputed, right? We've been litigating this case in the prior action and now this case for some years. And the reason that Hedman received an offset from the judgment and the amount of Occidental settlement is that it's governed by subsection A. Subsection A is the provision that gives the set-off, right? The set-off either for an equitable apportionment amount or the amount of the settlement. And Hedman has disputed how subsection A applies in the prior action, but it's never disputed that subsection A does apply, right? Hedman got a set-off as a result of the settlement from Occidental. So we think in terms of statutory text, there's simply nothing to go on there. To the extent that Hedman is arguing it's suspicious anytime an employer and an employee enter into a settlement agreement, it just doesn't fit the facts of this case.
I guess what counsel is really saying is because he wasn't able to get any discovery on what that settlement was all about and how much and the terms, that we can't make that judgment that it wasn't, justified.
Sure, and we cite case law in our brief about this, but the amount of the settlement agreement just standing alone can't suggest an improper purpose, right?
Well, I suppose if it's $3, it could.
Well, I mean, right. So first of all, there's no allegation about what the amount is, right? We know that it's not a nominal sum because we specifically include that amount in the release so that it complies with the statute. The statute says a settlement qualifies if it's more than $1, right? It doesn't say if it's more than $10,000 or if it's more than $100,000. It says if it's more than $1. Right? There's no statutory hook to impose some other kind of arbitrary cutoff. And I note here that, there's the Friend v. Dibble case, which dealt with the prior version of the statute and said even a nominal sum is enough unless there's some reason that the plaintiff would enter into the settlement agreement for something wrongful, right? Some improper purpose. It can't just be my claims stink, so I'm going to settle them cheaply. I'd also note here that and this is a point made in the Wilson case from the Illinois Supreme Court that overruled one of the cases that Hedman cites. We cite it in our brief. But it notes that in interpreting a somewhat different statute in Illinois, that it's not as if a plaintiff can't file a claim against his employer, right? Occidental would have an affirmative defense and a valid one, the workers' compensation bar. But the statute doesn't say a settlement of a meritorious claim, right? It's any release for a person liable or claimed to be liable. It refers to tortfeasors, not defendants. So even though Occidental wasn't a defendant in this case, it still claimed to be liable by Hedman. And of course, the threat of liability was very real. There's also an argument I heard this morning that maybe one of the theories of improper cooperation is that the Viglietta's agreed to help Occidental with its motion to quash. And that's inconsistent with the record. I point to record page 70, which is the hearing on the motion to quash. The Viglietta's counsel said, we're not taking a position. This is between defendants and Hedman. So that certainly didn't occur. I'd also note every settlement agreement is confidential. There's this agreement that this was somehow secret. There's an agreement about timing. I'm not sure that I understand why the timing here would be suspicious, but we do cite plenty of cases that say there's no evidence of collusion, even when a settlement is entered into after a third-party claim is asserted. And then finally, I'd also argue that there's no basis for the estoppel argument that was raised. There was no material misstatement here unless Hedman is arguing that Occidental actually was a former party who settled. And I think it's undisputed they were not a former party who settled. There was no misstatement. And then there was no detrimental reliance because, as this court has already ruled, there was no availability of equitable apportionment to begin with. Unless the court has any questions.
Thank you, Mr. President.
Thank you.
Next case for argument is number 212. Scott A. DeLeese versus FBBT U.S. Properties LLC. Mr. Seymour is with us remote. Mr. Gorski, how do I pronounce your client's last name?
Delisle.
Delisle.
Yes.
Okay, thank you, and you may proceed.
Good afternoon, Your Honors. Jonathan Gorski from Dolce Panapino on behalf of Plaintiff Appellant Respondent Scott Delisle. I'm going to take a page from the appellant's book a moment ago. He started his argument by saying that was a very simple case. This is a more simple case under labor law section 240. On December 3rd, 2018, when Mr. Delisle returned from his lunch break, his stepladder was not in the location where he left it. After a short search, he found the stepladder, but the stepladder was not in the condition that he left it. The stepladder had been modified. Socks had been taped to the feet of the stepladder to protect the newly installed tile floor. Unsurprisingly, as Mr. Delisle was climbing that very stepladder to install an exit sign, the stepladder moved. He lost his balance, fell, and sustained injuries as a result.
Well, it seems like what the crux of the issue here is your client's testimony. I think the witness was the fall was unwitnessed, correct? There's no witnesses to the fall. Do I have that right?
That is correct, Your Honor. It is unwitnessed, but under the Curbis versus LP Simonelli case, the fact that an incident is unwitnessed is not sufficient to raise a question.
I'm not arguing that, but so we have an unwitnessed fall. Your client says that a man named John, who was working there for CSL, he believed, took his ladder while he was on break, put some socks on it, tied it up, tube socks, and your client had the impression that this John with a red beard wanted him to keep the socks on. The other side says, we don't know of any John. Are we supposed to just take your client's testimony at face value, about his testimony about the socks, about this John person, about John person suggesting that he keep them on? We're just supposed to accept that as true. Correct.
Well, Your Honor, Mr. Delisle testified under oath. That's the evidence that's in the record.
Right.
There's no evidence in the record that there were not socks on the stepladder. The closest that the defense have to evidence that there aren't socks on the stepladder is the defense witness testimony that they were not aware generally of socks being on stepladders at this construction project.
Your client didn't mention anything about socks when he was interviewed for various incident reports and so forth.
Okay. So I want to stick to your initial question. So the initial question was about the socks being on the stepladder or not. And there's no evidence that there were not socks on the stepladder when Mr. Delisle fell. The second part of the first question was about this instruction that Mr. Delisle received from John from CSL. Again, there's no evidence in the record that this instruction was not given to Mr. Delisle. There's no evidence whatsoever. The defense cannot criticize an incident as unwitnessed, as I mentioned earlier. Just the same, the defense cannot criticize a incident as uncorroborated by independent sources. That's not sufficient to raise a question of fact. The only evidence in this record is that there were socks on the feet of the stepladder at the time of the incident, and that Mr. Delisle received an instruction from a CSL employee by the name of John, who he described, that instructed him to use the stepladder with socks on its feet to protect the newly installed tile floor. That's the evidence in the record.
I'm not sure I'd call it an instruction. Your client said he got the impression that this John with a red beard didn't want him to take the socks off. It's not quite as forceful as I am instructing you to do it this way.
I think it's more than that, Your Honor. In my reply brief, I bolded and italicized a specific statement from my client in his deposition that said that John from CSL told me, and that's the way I did it from that point on. Now, CSL is the owner, as Mr. Delisle testified, the owner of the construction project. The CSL representative who testified in this case testified that they were in charge of the project, that they controlled the project. So when you receive an instruction and someone tells you that's in a position of authority at that project to use the stepladder with socks covering its feet, Mr. Delisle is under no obligation at that point to demand a safer method. He's under no obligation, and there's no expectation that he would refuse that instruction. That's the Finocchi case that this court decided just a few short years ago. In that case versus Live Nation, a stagehand was directed to lift a box manually into the back of a tractor trailer. There was a forklift that was available. However, once the stagehand was given that instruction by a stage manager, who, whether that stage manager had the authority or not, that's what this court said. Once he received that instruction He could not be the sole proximate cause for merely following that instruction.
Would you agree that without the instruction, then there's an issue of fact on sole proximate cause? If your client if he put the socks on himself on a ladder that was perfectly adequate, perfectly safe, if he put the socks on himself, that would be an issue of fact, at least on sole proximate cause. Or if he found the socks on the ladder, somebody explicitly put them on there and he just used it that way, that would be an issue of fact of sole proximate cause. Would you agree with that?
So if
It's
Mr.
the
Delisle,
instruction that gets you out of the.
so the sole proximate cause defense, it's defendant's burden, and the defendant has to show that there's an available safety device, that plaintiff is knowledgeable of the availability, that plaintiff knows that he's expected to use that device, for no good reason chooses not to use the device, and had the plaintiff not made that decision, the incident would not have happened. Okay, so under that framework, it's defendant's burden on that issue. Plaintiff didn't make a choice here. There was no choice made by plaintiff. When he came back, the socks were on the stepladder. Now, had he decided,
Can I ask just one question to it? Something bothered me in the record reviewing it. This wasn't the first time that there was a mechanism in place to protect the floor. There was this other procedure that the plaintiff used earlier in the morning where he had like a piece of laminate or some type of material under the ladder that he was going to use to protect the floor. So the idea that the feet of the ladder, the rubber feet that prevent it from slipping, were in contact with the newly installed floor, that's not true anyway. That there was something in between. So I thought that was the first thing. The second thing, I thought that the individual from CSL that the plaintiff spoke to took that piece of laminate away so that he didn't have the option of using procedure A anymore. But that was missing, gone. You would have had to find that again.
that is correct, Your Honor. So in the morning, he's installing recessed lights in the front of the building, and he's using what he described as underlayment, which is a piece of laminate. It might have just been a piece of cardboard. I don't know what it was, but he was setting up the ladder on that laminate, cardboard, whatever it was. And he testified that that gave him the grip that he needed to do his work. When he comes back from lunch.
But that's not his idea either. He doesn't have an incentive to repair the floor. Somebody told him that we have to repair this new floor.
Yeah,
we have to protect the new floor.
Your Honor, it's in the record. It's not highlighted in the briefs, but there is a specification document. And in the specification document, it says that newly installed tile floors must be protected until substantial completion. So however that's done, whether it's laminate or whether it's the socks, it doesn't matter so long as that floor is protected, because CSL doesn't want to pay the flooring contractor to come back in and fix work that was already done.
Your client, once he comes back from lunch and he sees the white tube socks tied to the step ladder, the feet of the step ladder, did he ever go look for this laminate that he had been using previously? So it sounds like he just rolled with the socks without even making any effort to find this laminate.
Under Finocchi, he's not under any obligation to demand a safer method. And what this court said in Finocchi is that it would ignore the realities of a construction site and the disparity in power to expect a worker who's not in that position of authority to refuse an instruction by a superior. Now, when he comes back, there are socks on that step ladder. Now, if he had chose to use the ladder with socks on the feet of the step ladder, that is still not sole proximate cause. My argument is that is at most comparative negligence, and comparative negligence is not.
If he was instructed.
Well, no, I don't think he needs the instruction.
If he just did it on his own, say, I think it's a good idea to put some sweat socks on here and then.
Well, if he puts it on his own, separate conversation.
Okay.
I would agree with Your Honor. If he put the socks on by himself and he knew that he was supposed to use the ladder without socks, I think they get to sole proximate cause. But in this case, coming back and seeing a ladder with socks on it, even without the instruction, using that ladder, that's merely comparative negligence. That's not a defense to a labor law section 240 violation.
A lot of good points, and I not necessarily against you. What's uncomfortable about this case and some other cases is where we're taking one person's word for everything. We're taking your client's word that this mysterious John person with a red beard put the socks on. We're taking your client's word that there were socks on there. We were taking your client's word that this mysterious John told him to keep the socks on. And we're taking your client's word as this is how he felt. Maybe that's just how labor law works. The other side hasn't raised an issue of fact. I'm not sure they're in a position to do it. But I think perhaps they could have done a better job of, through discovery, showing there's nobody named John who works here on that day. Show us timesheets. Show us, bring in more people to show that there is no such John with red beard who was in a position for CRS to be telling anyone to do anything. But we are relying on the veracity of your client's testimony, and he has not been cross-examined in front of a jury.
Respectfully, Your Honor, what else do we have in cases than testimony? It's not unusual in a labor law case to have an unwitnessed accident. It's not unusual in a labor law case for a defendant to criticize a plaintiff's version of the incident as uncorroborated or unwitnessed. That's not enough. That's what this court has said over and over and over again. Once plaintiff meets his burden, and plaintiff met his burden in this case by establishing socks on the feet of step ladder, that the ladder was inadequate, and that the inadequacy proximately caused the incident, it is defendant's burden at that point to create a question of fact. And there is nothing in this record creating question of fact. Like Your Honor said, they could have come forward with some evidence. They could have produced John.
They produced one witness that said there was no employee with a red beard. Well, how does that play into it?
I'm sorry, what was that, Your Honor? I missed it.
I said that there was testimony from another employee, Roberts, who testified that there was no employee with a red beard. And there was no one named John. There was someone named Jay, but he didn't have a flaming red beard.
John Roberts is a Barker representative. He was the superintendent for the general contractor. This was a CSL employee that was at the site. Now, this was a rehabilitation of a pre-existing space. There were CSL employees on this site. There was a project manager. There was a gentleman that was deposed, Mr. Vian. There were people on this site from CSL. This was nearing completion. What this person was doing at this time was hanging signs outside of doors, interior doors, to say that this is the bathroom, this is the lab. That's what this person was doing. This was nearing completion. Plaintiff came forward with evidence through his testimony that a gentleman by the name of John from CSL instructed him to use the ladder with socks. Defense has a burden once plaintiff meets his burden on summary judgment to create a question of fact.
Right, but what I'm saying is there was a witness that, for whatever they were able to come up with, said that there was no such person with a red beard. Whether you think that that's conclusive enough but that is in the record. So my question is, why isn't that enough to create a question of fact on the 240 issue? Well, because that would seem to support, or could possibly support, an argument that that's the sole proximate cause issue.
Again, Your Honor, I would say that was Mr. Roberts. He was a Barker representative. He was not a CSL representative. The CSL representative did not say that there was not a person by the name of John with a red beard at this site. That was a Barker representative who was the general contractor.
Person who was allegedly there. We accept the truth of his testimony, just like we accept the truth of your clients. And he says nobody that day was there with a red beard. Isn't that?
Respectfully, Your Honor, that's not the testimony. He did not say that nobody was there on that date. So whether there was somebody there on that date or not, the only person that has knowledge of that, and the only person that testified under oath in this case about the conditions then and there existing, was Mr. Delisle. And
does it matter whether somebody instructed him to use the ladder? They put socks on the ladder he was using, and he was continuing to do his work after his lunch hour. Does it matter what somebody told? It's very clear to me what the implication is. Here's your ladder. We put socks on it. Do your work.
And I think that's what Justice Lindley was hinting at earlier when he had asked about, would there be a sole proximate cause defense if Mr. Delisle modified the ladder? And I would concede that there would be. But in this case, when he goes back inside after his lunch break and there are socks on the feet of the step ladder, at most, his conduct is comparative negligence.
Well, you would have labor law 240 claim and perhaps liability, even if there were no socks on the ladder. The ladder failed and he got hurt. Socks or no socks, right?
Correct. That is a secondary argument that's contained in my brief, that irrespective of whether there were socks on the ladder or not, there's a labor law section 240 violation, because labor law section 240 requires more than the mere provision of a safety device. It requires that that safety device be constructed, placed, and operated so as to protect the worker against an elevation-related risk that is presented by the work. In this case, there is proof, the plaintiff's testimony, that the ladder moved. At that point, that's evidence that the ladder was not properly placed. And I cited a litany of cases in my brief that stand for that exact proposition, that once a ladder moves, that's prima facie evidence that the ladder was not properly placed. That's a labor law section 240 violation. So we have two 240 violations here. We have the socks on the feet of the stepladder, inadequate. Everyone agrees. Undisputed, inadequate safety device. Defendants admit that in their brief. Then we have a second violation, even if we accept, for the sake of argument, that there weren't socks. And I'm not accepting that, but I will, for the sake of argument here, that there weren't socks. We still have a placement issue here. And the fact that that ladder is not defective, the fact that that ladder didn't have socks on it, does not
doesn't mean it couldn't failed or it was not properly placed.
Exactly, Your Honor. It does not create a question of fact on placement. And here, the ladder moved. It wasn't properly placed. That's a labor law section 240 violation.
We understand. Thank you very much.
Thank you, Your Honor.
We're going to go to Mr. Adams. Mr. Seymour.
May it please the court. I'm not even sure where to start after all of that. So let me start with this one. The socks versus no socks. I'm not going to argue whether or not it would or wouldn't be with no socks. I think he's possibly right, but he misused the safety device.
I just have to ask you to stand in front of the members so everyone at home can see you. They're going to see you. They just want to hear you.
The fact of the matter is that when you look at a sole proximate cause defense, okay, and Mr. Gorski loves to talk about the sole proximate cause defense as creating a question of fact. Let's be clear. The sole proximate cause defense leads to a dismissal if the sole proximate cause defense is upheld. If there are questions of fact about any of the elements, then it's a question of fact all the way around. But let's talk about what those 5 elements are, right? I mean, we're all very familiar with them. You start with the fact that there has to be an adequate safety device. Everyone agrees that an adequate safety device would have been that ladder was in perfect condition. It had rubber feet on the bottom. It was open. Both sides had been latched. So there's no argument that
sans socks, it was a very nice ladder.
Exactly. Number 2, that adequate safety device, the ladder, had to be available. And clearly it was available because all he had to do was bend down and take the socks off. So it was available. That's number 2. Number 3 has to do with whether or not he knew he was supposed to use that safety device in its appropriate configuration. Again, there's no question about that. He testified about that at length and talked about that that was the way I was taught. I think that's at page 104. Clearly, he was instructed and knew he was to use it that way. He didn't want to use it that way. He said he didn't use the word unsafe. He said it was shaky and he didn't want to do it. And that's not how he was taught. So we've got element number 3. Element number 4 has to do with he then misuses the appropriate safety device, which he did by what? Failing to remove the socks.
But on 3 and 4, he claims he was instructed.
Well, that's 5.
Okay.
That's the no good reason, right?
Okay.
I mean, that's his entire argument is based on no good reason. It's based on the fact that this tall gentleman with a red beard who hinted at him and gave him the impression that he was to use it that way. There's no allegation he was.
Hey, yeah, that's not the allegation. The allegation is that the guy took his ladder. He went to lunch. Guy took his ladder, modified it, took away the platform or the laminate or the underlay, whatever he had ahead of time, put that someplace else. And then the guy went to go back and get the ladder and he said, this is the ladder. And that was it. So it was more than just a hint, wasn't it? He actually is the one who modified it.
Your Honor, I hate disagreeing with judges, but I would have to disagree with you. There's no testimony that the laminate was gone, that the underlayment was gone. In fact, his testimony during his deposition was that he chose not to go back and get the laminate. He said, I would have had to take the socks off in order to do that. I would have had to go back to where I was working before and get the underlayment. Clearly, if you want to say that the underlayment then.
So you think the record says that he left the underlayment back in the original spot where the ladder was? That's what the record reflects.
He doesn't say that he left it in the original spot. What he says when he was
What about the witnesses that were there that day?
when he was making his decision that day, Your Honor, what he said was, I chose not to take them up. I would have had to go back and get the underlayment. He didn't say it was unavailable. It was
Say anything about it. He said, he didn't say it was gone. He didn't
He
say
did
that
not.
it was no longer with the ladder.
He did not. Remember, the ladder was in a different position.
Right, because the other worker took it from him.
Someone took it from him. Was it I mean, we get to there's a massive question about who this person is, right? I mean, Mr. Roberts specifically says, I'm on this site. There's nobody here. No tall white man with a bushy, bright red beard.
Couldn't CSL, submitted an affidavit from somebody from personnel and said, these are all the people who were, we checked the timesheets. These are all the people we had on the site that day. There's nobody named John. These are the people, here's their photographs. There's no redheaded tall guy, or a red bearded guy named John. And that would have clearly raised an issue of fact. Right?
I think, Your Honor, for the exact same reason that Mr. Gorski wants you just to believe whatever the plaintiff says in this unwitnessed accident, whatever he says about who it was that talked to him and what was said and what was suggested to him. The fact that Mr. Roberts testified there wasn't anyone there that day, you have to take that as well. But
Do you think all this goes to the jury?
I think so. I think so. If the court if the court continues to think that there's a possibility that Mr. Roberts was wrong, but let me take a step back. It's obviously a hearsay statement coming from the plaintiff about what someone else told him.
Was that argued below?
Pardon?
Was that argued below? I didn't see it in the transcript below. I didn't see it in the motion papers below. The argument about hearsay.
I have to be completely honest with you, Your Honor. I don't know. I didn't write that. I just recently picked this up to argue this appeal. I did not argue below. Mark Schultz from my office had argued that below. I don't recall whether or not the hearsay argument was raised. I don't know that it
wouldn't be an exception as a party admission.
Well, it's an exception. Is it a party admission? In order to say it's a party admission, don't you have to then accept that it was a party? I mean, that's circular logic to go with a party admission. You can't do
That's
that.
what we do here sometimes.
Well, it's not hearsay if it's not offered for the truth. So there's no exception, but.
Let's stop right there.
Okay.
That's an exception to hearsay. And then you're saying that he's not accepting that that was a true statement. He's not accepting that that was someone from CSL. If it's not from CSL, who the hell is telling him?
I want to ask you the same question that I asked Mr. Gorski. Does it matter? He comes back from lunch and the ladder he was using now has socks on it. And I mean, certainly the implication is use this ladder. We've got new floors down here. We want them protected. You know, it doesn't matter whether somebody directed him. They changed his ladder and made it unsafe. Well, it doesn't matter who told him you got to use this anyway.
If you come back from work, yes, it matters greatly. It's a crux right here. It matters a huge amount. If he comes back and looks at if they had come back and they had cut one leg off so it was 6 inches shorter, and he knew he was supposed to not use a ladder with one leg 6 inches shorter, and some guy he's never seen before, doesn't know who he works for, the proof is from an admissible form from Mr. Roberts that he wasn't someone that was working for CSL at that site, says, oh, you can use it. Go ahead, use this ladder. What if it's some guy off the street that's just walking in?
You're not suggesting that the plaintiff was supposed to ask him for his ID?
I'm suggesting that if someone who's unidentified tells you to do something, you have certain responsibilities in this world.
If you know it's unsafe.
If you know it's unsafe. He knew it was unsafe. He looked at that ladder and said, this ladder is unsafe. I know that's not how I was trained. I was trained not to do this, but I'm going to do it because of this guy with a red beard.
Plaintiff had, my understanding is there were two other workers there for his subcontractor that he worked for. There was a man named Austin Caldwell and Dennis Little. They were at the scene that day. Is that your understanding as well?
That's my understanding.
Right. So this whole idea, were there socks on the ladder, is a factual dispute.
It is.
Couldn't you have subpoenaed them and, or interviewed them, got affidavits? They would know, right? Because their friend fell. They're there. Perhaps they saw the ladder. We don't have anything from those two individuals, right?
I agree. You're putting that burden on me as opposed to on the plaintiff.
I'm saying that you have the issue, you have the burden to raise an issue of fact. I'm not, his client testifies under oath, and I guess under the rules that we have to accept everything he says is true. This will be, this
we have to accept
one way
everything.
to check it is to bring in other people and say, actually, no, I didn't see any socks on that ladder.
We have to accept it as true in opposition to my cross motion. We don't necessarily have to accept it as true in support of his motion. That's not the way that it works. It's the.
Well, but if he meets his burden, then the burden shifts. And you have
Agreed.
to raise an issue of fact as to that the accident didn't happen the way the plaintiff said.
No.
The plaintiff also talked about all the other contractors that were there that day. He mentioned that he mentioned exactly what the CSL worker was doing, the signs, and somebody put those up, right? Somebody put up the men's room sign. CSL can find out who did that.
Your Honor, I do not believe that the burden is on me to go beyond what is in the record, beyond what is done there.
I guess it depends if you want to dispute it. If you want to dispute that this accident didn't happen the way plaintiff claimed, you ask the plaintiff, well, who else was there? And if the plaintiff tells you there were these contractors and those contractors and these guys, and there were these people doing work, and the guy that I talked to was doing this specific work, this specific job at this site, at the exact, and he gives you the date and he gives you the time. And CSL's in charge of hiring, or at least having subs hire all the workers that are present at the site. Plaintiff, he goes to the doctor and he's off work. I don't understand why CSL wouldn't be able to find out everybody who was there that day. And yet the three witnesses that are produced for deposition for the defendants, none of them were there that day.
Yeah.
Why is I don't understand why that's insufficient.
Well, number one, I don't represent CSL. Okay. But beyond that, there is testimony under oath that there was no one there with a tall white man with a red beard. This all hinges. I mean, the other four elements are clearly met for sole proximate cause. This all hinges on whether or not he was told by someone from CSL and that something which he assumed, which he interpreted, which he thought meant he should continue to use it. He's very clear. His own testimony is that he felt he was being encouraged to use it. He was not instructed. I mean, Mr. Gorski can say instructed 1,000 times. It doesn't make it true. His own words, his own testimony.
You don't represent CSL.
Pardon?
I have you representing CSL and Berger.
No.
And I have Mr. Seymour representing FBBT.
Oh, well, then I do.
All right.
All right, well, we get the gist of it. Anything further, last remarks?
The only other thing that I want to talk about, Your Honor, is the inconsistency of his reports immediately following this. And again, Justice Lindley, as you said when we started out, this is all very difficult when it's an unwitnessed accident, particularly when one version of the accident is provided, and then counsel is retained, and then another version of the accident comes out. And I've been in front of this court arguing that someone who fell off a ladder and has said the ladder shifted, and where all he said was, I missed my, I lost my balance. But this one is different. This one is different because of specifically what he said. And he specifically said that he slipped.
Are you quoting the transcript?
I'm quoting the transcript, and I'm quoting the one was the workers'
reports. Incident reports and workers' comp.
Yeah, there's the workers' comp, there's the accident report, there's when he goes to the emergent care. He says, I slipped while ascending. My foot slipped.
Those papers submitted in support of your motion
Yes,
or in opposition to the plaintiff's motion?
yes,
Are they in the record that way?
yes.
It looked like Mr. Seymour might have submitted them, but I didn't see that your side submitted.
They're in the record.
Matter.
I don't believe it matters. They're in the record. I mean, Mr. Seymour and I are joined in our arguments here. As you can see by his papers, he basically was riding along coattails with me on this. But it's not the same as when you say, I fell off the ladder. Or I whatever. When you specifically explain how it happened, my foot slipped off the rung and I lost my balance and I fell. No mention of socks and absolutely no mention of the ladder moving. This case is different. It's not simply fleshing it out once you have retained counsel and you're at a deposition. You're not just fleshing it out. You're coming up with a completely different story.
You think there's enough here to get it before a jury to see if they believe this plaintiff?
Exactly. But with regard to that, with regard to the first section, I really believe that there's enough there to uphold the sole proximate cause defense. Because I don't believe that there's any evidence that the individual that told him what to do was an employee of the owner.
Well, thank you very much, Mr.
Okay. Thank you, Your Honor.
Mr. Seymour, anything you want to add?
Your Honor, just briefly, I think my position was pretty clear in my papers, that, no one appealed from the specific cross motion that we made on the contractual indemnity that was granted, under condition. So, rather than getting into the merits of the arguments that either side made, it's really just to clarify to the court that, I guess, if the court does nothing and just affirms, we're status quo. If the court agrees with plaintiff and there was the labor law violation, then the condition precedent of my contractual indemnification claim has been met, and the court's decision should then grant me contractual indemnification as a matter of law. On the flip side, if the court is going to change the trial court's order and dismiss any claims under the labor law pursuant to the arguments that we obviously made at the lower court, but really have been advanced by Mr. Adams on behalf of his client at this time, we get the benefit of those as well. So unless there's any other further questions on our specific point, otherwise, it's been a long enough morning and now into afternoon for you guys, and I will stop talking.
Thank you.
Thank you.
We're going to call two cases now, 213 and 213.2. Same attorneys, same legal issues, different properties, different towns. It's matter of Farmington, New York Farmington LLC versus assessor of the town of Farmington. And then 213.2 is matter of solar advocate versus the assessor from East Bloomfield. Good morning, Counselor. Is it okay to you, with you, if we argue the same legal issues and everything? We call them separately, you'd probably just be repeating yourself. Am I correct?
Yes, there are some differences. Actually, let me get my papers out for the other one.
We'll start with 213 then, the Farmington case.
Okay, good afternoon. My name is Sheila Shalafo. I'm here on behalf of the town of Farmington and the county of Ontario. Both of these entities adopted local laws opting out of RPTL 487, which is a solar exemption for real property tax. And one was, I don't know if you want me to do the facts together or?
No, yeah, we understand what happened here,
Okay.
that the towns opted out.
Yep.
And they sent the notice, at least to the New York State taxation, finance. That one is where they had the public register. NYSERDA is the other one, and there's a question of whether the notices got sent to NYSERDA. The trial court relied on a third department case to say you got to send them to both.
Yep.
Otherwise, the local opt-out laws are invalid.
Correct.
The legislature comes the next year and says, no, they pass a law immediately. They overturn the third department case and says, as long as you have one or the other is good.
Yep.
That's the factual backdrop here. The towns say they might have sent it to NYSERDA, and NYSERDA doesn't have any record, but let's assume for the sake of this argument that it wasn't sent there.
It's perfect. Yes, exactly. That's
So-
exactly what I was going to say.
Could you address the retroactivity
Yes.
of this law that
So,
was passed in response to the third department case? A, whether it's retroactive, and B, whether we could address it, because it didn't seem to be raised below. It's not preserved.
yeah, it's true. Obviously, if I would have knew it was available, that was a strong argument for me. I wish I would have
You
raised
just
it.
weren't aware of the statute, I take it, at the time?
Weren't aware of the statute, just kept, researching the cases, not even thinking that the state legislator would give this such a direct answer. So my argument on the applicability of it is that this would have changed nothing if we brought it up or we didn't bring it up, because what 497 is a codification of what the case law already is. The case law that we raised throughout this matter, which is if you have a jurisdictional defect, the courts have addressed how we're going to determine if that if the procedural error constitutes a jurisdictional defect. There's two things they look at. One is they say, well, was there a detriment to the property owner or to the public? Obviously, there wasn't here. It sat in the file. Any mailing that was done was mailed to, and by the way, we were one of the first towns that NYSERDA received an opt-out from, because
Farmington?
Pardon me?
You're talking about Farmington?
Oh, no, actually, I'm not. No, you're right. It's an Ontario County argument, but my point is they didn't even get designated to accept these opt-outs until 1996. So the 1977 one was pretty much one of the first ones, if not the first one. But what the courts do is look at two things. One is whether the procedural error is substantive, and that's if there was some kind of detriment. And the second is, does the statute expressly state that if you don't apply, if you don't do the procedural step, is the local law invalidated? Here, of course, it didn't say that. And the cases that the lower court relied upon, Marcus and Sterling, they do contain that language. It's Secretary of State filing, it's mandatory referendum. Those are the kind of cases that are jurisdictional defects, not this case where there's no mention of the effectiveness being tied to the procedural step.
So like an example would be the municipal home rule law, which says law should become operative only if approved. Like
27, the Secretary of State, the statute that requires you to file a local law with the Secretary of State, that has that language. The Municipal Home Rule 24 has it, that talks about a mandatory referendum. That's where that is coming in.
487 just says shall be filed with the two entities.
Exactly.
Taxation and finance, and then NYSERDA. In looking at the Laertes case from the third department, it looks like what they relied on was People v. Schoenfeld. They write about, ordinarily you would construe the language in the statute as peremptory in the absence of circumstances suggesting a contrary legislative intent. And then it goes on to talk about they were unable to discern the contrary intent. We also have other cases, Allscott, only a departure in substance will invalidate a municipal enactment. How are we to read those two?
Yeah, and there is some differences even within the departments. But I think the biggest difference with Laertes is that's a school district resolution. We have a legislative action here, a local law. So when you start turning over local laws, the standard's a heck of a lot higher. So that's the argument there.
You think that the third department case is distinguishable on the facts?
I think it's
We don't necessarily have to disagree with the third department?
Yep. I think it
Judge
is.
Doyle, who had these below, felt constrained to follow the third department. And he, which is correct, if it's the only authority across the state, you put this in a footnote that trial courts in Western New York have to follow an appellate division from first, second, or third, unless there's contrary authority from the fourth or court of appeals. So he said, I have to follow Loretus. We don't, but he did.
I don't agree that he did either. I think that the reason that they did is because they accepted that without looking at the contrary law that we provided, which is, makes this distinguishable. And this case, he didn't distinguish this case. He could have done either of those things. He didn't even address our law. Either did the petitioner. I mean, it's like nobody's even listening to this argument that we're talking about a procedural error in the adoption of a local law. That's the issue.
No effect. There was no reliance on these cases. They decided the petitioners decided to build their solar farms when they knew that these towns had opted out.
Exactly.
Only after Loretus, they're like, oh, wait a minute, let's get
it's a windfall. They want a windfall.
Let's go check with LaSalle. They did a FOIL. And oh my goodness, they didn't file it. Let's get this windfall. It wasn't like some people would expend all this money thinking they're entitled to a tax refund only to have the rug pulled out from under them. This is the opposite. They built with the assumption they were getting nothing. And
that's true in both of these cases.
Both of these cases, it would just be by happenstance that, oh, they might have made a mistake. Let me get this money, which I'm not blaming them. Nothing wrong with that, but there's no reliance here.
No reliance at all. The other issue that I wanted to address is the only way you can challenge a partial exemption is in an Article 7 case. You can't bring an Article 78. It's not like a whole, a property that's wholly exempt, like a church or something. So the reason that's significant, and it's significant to the statute of limitations argument, is the Board of Assessment Reviews can only determine eligibility. I mean, nobody is arguing that a Board of Assessment Review can determine that a law of the county or the town is invalid. I mean, that's just outside the scope of their jurisdiction. So what the petitioners did is said, okay, well, we got to, in my opinion, bootstrap our claim that this is an invalid local law. That's fine. Okay, they've bootstrapped it, but I believe the claim should have been brought as an Article 78 back, 4 months after the local law's adoption. And even at the latest, they knew about this in March of 2021. They brought this action in 23. So they can claim the exemption whenever they want. But if you're going to challenge this local law on, that it's jurisdictionally defective, you can't wait 2 years after you find out that it's jurisdictionally defective. So that's our other argument I want to make sure.
Back to the retroactivity of the section 497.
So
it was passed in April of 2021, and it overruled the third department case.
Correct.
You didn't raise it below, admittedly. Can we? How can we? Because that seems like a winner for you. If you had raised it, sounds like a winner for you now, but it's not before us. How would we address that? What are the ways that we can get to that issue here?
Well, I think you can get to that issue because the same exact statement that's in 497 is in my cases.
Right. But I'm talking about procedurally. Would we reach it in the interest of justice? Do we have that jurisdiction in a civil case?
I think you do. I mean, the issue is that there's nothing that would have been changed here. There's no prejudice by this. This is a statute, it's not, it's.
So this is a strictly legal issue?
Yes, and it was out there.
It's an exception to the preservation rule for strictly legal issues?
Yes, that sounds, that's good. I basically, first of all, I don't see any problem in using the case law out there. If you choose to use this as well, I think you're more than justified.
In terms of the retroactivity, I'm not sure that petitioners would agree that it's a winner argument. The one thing they raise in their briefs is that you're, at least particularly in the other case, you're asking this to be retroactive to go back years.
Yep.
Decades. And that's, typically not done, but that's what you would be suggesting. If you had the argument, if you're able, even though it's unpreserved, if you're able to bring it, or we want to entertain it, how do you explain that?
I'm not sure if the court is familiar with Judge Vazana's decision.
Yeah, get right here.
But he lays it out great. Basically, what he says is normally the rule is that it's not retroactive. But here, when it's remedial, when it was designed to rewrite an unintended judicial interpretation, which is exactly what they were doing, and the legislator conveyed a sense of urgency. They adopted it within a year, as you said, and they also made it effective immediately. But I think the most important thing to me is the fact that they singled out the Loredas case. So if they make it not
retroactive, they didn't have to single it out.
They didn't have to say that at all.
But wouldn't the counter argument be that they didn't specifically say in the decision it was retroactive?
Yes, I guess that's the counter argument, but I think it meets all of the tests that the cases lay out.
I think we understand your arguments. Thank you.
Thank you.
Good afternoon.
Good afternoon. May it please the court. Henry A. Sommerfeld, Hodgson Ross, on behalf of the respondents, the solar developer and company owners. There are a number of issues as evidenced from the questions from the bench, and I'll take up first retroactivity. There was no mention in section 497 that this statute would be retroactive. And of course, when interpreting a statute and whether it's retroactive and has retroactive application, that is the first thing the court will look to.
So Judge Vazana got it wrong in the Ontario County case?
Yes, Your Honor, and that is on appeal. It's not part of these two cases, but of course, a pending appeal.
So counsel's argument is if it's not retroactive, why mention the third department case?
Because
which was
that's
in the rearview mirror at the time.
Because that was the only case that addressed the issue. But it seems to me if the intent was to say because of Laertes, we're enacting this statute, then they should take the next step to say, and therefore it's retroactive. They didn't do that. The legislature did not do that when it enacted 497.
If it's retroactive, do you lose?
If it's, well, Your Honor, no, because you have to then perform the retroactivity analysis, right? So there are three issues on this point. First is it's not preserved. It's not before the court. The court can't consider it to the.
We don't have authority to reach an unpreserved issue in the interest of justice?
In the interest of justice, as a question of law, the court can look to it, but generally this court has said, if it's not briefed, we're not going to consider it. But were the court to, on a question of law, say we can look to the statute anyway, though it's not preserved, the question is it retroactive? Based on the legislature's intent, I would say no. If the court says, well, we're going to consider it retroactive, then we go through the retroactivity analysis. And there are due process implications here. As Justice Nowak mentioned, this would reach back quite a while in both cases. So Ontario County's law, 1997. Farmington's law goes back to 2016. There is a reach back of years, and as we cited in our papers, a number of cases, the Mullen case that looks back to a 16-month period as excessive and unconstitutional on due process principles. Here we're going back a number of years, Your Honor.
There might be a lot of property owners having to come up with massive refunds if it's retroactive, right? I mean,
if the law was retroactive, it would protect the municipality taxing jurisdictions. If the court finds that it's not retroactive, we would be entitled to the exemption. And
right,
that
what I'm saying is if it is retroactive and the solar farm companies have been getting tax breaks all these years, they may owe that money that they didn't pay.
No, because the 497 addresses the opt-outs, right? So we're talking about if you had to file If the jurisdiction filed an opt-out and didn't do it properly by filing either with Secretary of State in the case of a local law and taxation and finance and NYSERDA, if you skip that step, the local law is still valid. Right? It has nothing to do with refunds. And of course, if there was any concern about refunds, those companies would have had a timely commence a suit to challenge. The time is now well past that. So there's no risk of refunds. The question is whether or not the companies get the exemption. And, you know, the Laertes case, yes, binding on the trial court, you know, instructive for this court. We would ask this court adopt Laertes if we get past the retroactivity question. This is a due process implication on retroactivity as far as the expectation. You're taking something away. And this is what the third department addressed in Laertes. This is a property tax exemption. And therefore, the court has to be hesitant, reluctant, I'd even say hostile to look to apply this retroactively.
Right, that's assuming that the law is inconsistent with prior case law. Counsel says it's just a continuation, it's just a clarification of what the law has always been.
I disagree, and we've distinguished cases that counsel have cited on multiple grounds. Counsel continues to talk about this is a procedural error, it should be overlooked. That's not at all the case, because if we put aside for a moment retroactivity and look just at Section 487 in the context of Laertes, and again, Laertes being the only appellate division case on this topic, the statute says shall file. And if the court looks to the reasoning of the third department, that was for good reason, shall file with taxation and finance and NYSERDA, because you are providing an exemption, or in this case, taking it away, eliminating the opportunity to seek the exemption, going back to the idea of due process rights, vested rights of an interest, because solar companies, obviously, this is an important exemption to them. Whether a project pencils, the financials of a project all surround upon what incentives and exemptions might be available. And on the flip side, what taxes do we have to pay over the life of a project? So the legislature, in enacting 487, said, we are going to create an additional filing requirement for towns, counties, villages, and cities. Filing with the Secretary of State alone is not enough. For school districts, of course, there is no such filing requirement. They pass a resolution. So everybody's on notice. There are databases maintained by both agencies, taxation and finance, and NYSERDA. And the record in both cases before this court today is NYSERDA has no record. The record in this case shows that in both cases, neither the town supervisor nor the assessor and county attorney had any record of this opt-out being filed with these agencies. And that's crucial. It's crucial because that, at least putting aside 497, was a requirement under the statute.
And this is like a forever exemption, right?
No, it's a 15-year exemption.
15 years.
15 year.
Okay.
And then,
right, so the towns can't, like, in the middle of this 15 years say, okay, we're now opting out. That's why retroactivity is important.
correct. And in fact, the opt-out timing is crucial because once construction starts, the window is closed to opt out as to any projects that have hit that marker. So a town is free, you know, the town and the county refiled or passed new opt-outs. Those are prospective opt-outs for all projects that come in. These projects were constructed and there was no issue. So the town can't claw back and change the course of dealing. And that's exactly the point, Justice Greenwood. You're changing something that relates to financial property interest and vested rights. So it's important that when the court look at this, that due process aspect is taken into account. And because of the timing that this would reach back, it would implicate every single case that we've cited that says this is too excessive, right? We're not talking a period of a few months. We're talking a period of years, which has implicated a number of cases, including this court's decision in Ruth, which has an extensive analysis of whether or not to apply retroactivity and held that it was not appropriate, and that in that case the statute was only forward-looking. And we would say that this court, consistent with that decision, should find that retroactivity doesn't apply because of the due process implications.
Since we have 2 minutes, if you want to wrap up, please.
Yes, Ron. I just want to touch on a couple of other items that were raised. it's important that the denial of the application is what triggered standing and made this issue right. There was argument in the briefs and by counsel about eligibility and the timing and going back to when maybe they were aware. I don't think the record says they were aware in 21, but nevertheless, the application for the exemption that was denied is what triggered ripeness and standing. We exercised and exhausted administrative remedies and timely brought suit. So that's really a non-issue. The only other thing I'll highlight is there were questions about why Laertes. I'll just reiterate that's the only appellate division case on the issue. We would ask this court in both of these cases to affirm and decline the invitation to see 497 as retroactive.
Thank you.
Thank you.
Yep. Last case is 213.1 Scanlon versus Miller Williams. 213.1. Good afternoon.
And please the court. I'll wait until Mr. Connor sits down. This appeal is simultaneously a unique legal dispute and a crucial matter for Buffalo, New York's second largest city. In 1945, and more so in 1994, Buffalo's finance board, its common council, delegated to its chief fiscal officer, its comptroller, the power to determine if, when, and how Buffalo issues serial bonds and anticipation notes first authorized by the common council. This broad but well-documented delegation differs from the case law cited by the petitioner respondents, has never been rescinded, and presents a matter of first impression for this court. Critically, the comptroller is not claiming the power to authorize bonds and notes. I will be discussing serial bonds with their annual principal installments, which are long-term instruments not exceeding the period of probable use of the subject projects, while notes typically have 1 year renewable maturities and are issued in anticipation of taxes, revenue, or bonds. There is no doubt that for over 30 years, Buffalo's comptroller has held the power to determine if, when, and how to issue anticipation notes and serial bonds authorized by the Common Council. Buffalo's Common Council delegated this power in its 1945 and 1994 resolutions, but retained the power to authorize the bonds and notes.
I have a question, okay? You mentioned the power of if, when, and how, but you didn't really address the question of whether, okay? That's the discretion.
If is whether is if. And I should have used perhaps the word whether instead of if.
No, I understood them to be quite separate, okay? I understood your point, but to me, your point was besides the point of this whole exercise that we're doing here.
Well, let me jump to that.
Yes, please.
Through the 1994 resolution, the Common Council, as the city's finance board, delegated to the controller as the city's chief financial officer, quote, its powers, in other words, the Common Council's powers, its powers and duties prescribed by section 21 of the local finance rule with respect to the making of determinations, the most important word I'm going to say at this podium, determinations to issue bonds and provide for substantially level or declining debt service. Now, meanwhile, that's the end of the quote. Meanwhile, section 21 of the local finance law states in turn that, quote, any municipality may issue bonds for any object or purpose having a period of probable usefulness, and then there's a formula. Respondents make much of section 3.7F of the city charter, but it only says the Common Council can authorize borrowing. It does not say the council can determine or direct whether to issue bonds or notes. The delegation in 1994 from the Common Council to the controller gave the controller the discretion whether the city may issue serial bonds.
Yes, Judge.
If
you're correct on that, could you have a fiscally conservative controller in Buffalo, say, look, I don't believe in debt. And I'm not gonna issue any bonds. I don't think that's healthy. Here we have controllers said, I'm not gonna, the cap's gonna be 28 million, but if it said 1 million or 0, does the controller have that authority under these resolutions from 1945?
The answer is her duties under section 2021 of the city charter, which specifies that she is to do an estimate each year of how much the city can prudently incur in debt.
And that's just whatever number she comes up with. She comes up with 5 million, say.
She has a whole staff that
Right,
does it.
let's say they come up with 5 million, which is, you can't run a government on that. And the city then, it's up to her whether to issue bonds.
I think that could be challenged on a certiorari basis rather than a mandamus basis, on the basis that it's an error rather than a matter of who has the discretion to, quote, determine whether to issue bonds.
If the council in those 2 resolutions that you're relying on delegated the authority on the decision not to issue bonds, but to determine whether to issue them, couldn't they take back that authority? And did they not do that by directing her to do this?
They have never taken it back.
So what they can do it tomorrow, just pass another resolution, say, hey, forget 1945, forget this other one. We're taking this back. They could do that right now as we speak, and this will be over.
Absolutely.
Okay.
But if you look at my opponent's fallback position, what he's saying is that the bond resolutions actually were the renunciation of the prior resolutions. But that doesn't make any sense, because the resolutions, which are in the record, they're around page 98, from February 18 of 2025, don't reference the 45 resolution, don't reference the 94 resolution, don't reference any kind of renunciation of those resolutions. So I don't think that is a renunciation of resolutions. I would expect that you'd have to do something explicit. And meanwhile, every year, including in September of 2025, when we went to market with around 29 million of bond anticipation notes, not bonds, notes. When we went there, the city clerk certifies that those 2 resolutions from 30 and 80 years ago are still in effect, so that the confirmation is there with each going to market. And this makes sense, because if the bond resolutions...
Doesn't the bond resolution specifically say hereby authorized and directed? It says directed.
Right.
How much more explicit does someone need to be than say you are directed to do something?
Your Honor, it says that every year that way. That's the language.
Well,
but
I mean, you're wrong on that, your argument here. I mean, just because, so what?
if I delegate my powers to Mr. Marks over here, who did wonderful drafting, and I do that, and then I purport to use that power that I've delegated to him without renouncing the fact I gave it to him, I don't have that power. I gave it to him. He holds it. That's what they did here. They gave the power, and it's been honored for years. There are tens of millions of dollars of authorized but unissued bonds that have been allowed to be. Yes, Judge.
It's not in the record. I mean, are you saying that in the history of the city of Buffalo, the Common Council has gone to market on financing, okay? And they have specifically said this language that we have here, and then, but the controller has done other things?
Yes, that's in the record. That's in the record from the...
Okay, go ahead.
In the affirmation of Barbara Miller Williams, the affirmation of Greg S. Szymanski, and they talk about... Yes, Judge.
No, I'm interested in your...
They talk about the fact that for years, tens of millions of dollars of bonds are authorized by the Common Council, which has retained the power to authorize bonds, but not issued by the controller, because the controller decides not to. An example is, and this is in the record...
Let me stop you for a second. Okay, so I get that. There is a direction, get these bonds. She pushes back. Isn't there an ability to push back again and say, I understand your concerns, but do it. We want this. We voted for this. We're the people who get to decide how we spend the city's money. I mean, I get that there could be a a question, maybe thoughtfully questioning some of the expenditures. But once that's done and brought to the attention and it's still voted, yes, you must spend it, you must get these bonds. Does she have the last word?
Because of the resolutions, yes, if they don't like her having that discretion, they should get rid of the resolutions. They resolved that the 45 and 94 resolutions
So
are
you
withdrawn.
are saying she has the last call.
Right now, she does.
Okay.
It says determines. I read the 94 resolution. I know you have. I'm not going to reread it at 106.
Thank you.
But they gave the power, and they gave the power on the notes in 45. In 94, the law was amended so that they could give the power on the bonds as well within months. They gave the power on the bonds. They wanted to give this power within months of the opportunity to delegate the power as the bonds. They made the delegation. This is very thoughtful and intentional. This is not something haphazard. And the fact that there's been no revocation, I don't know what happens to the Common Council.
There's one question I have just in regard with respect to this theory that the controller has this power, has had it all along since 1945. We have these reporting requirements, and we have this August report, the August 1st, 2024 report, where the controller advised that that the projects that received reimbursements in the form of state building aid, major city of Buffalo, those are the school district projects. The city of Buffalo projects that have dedicated revenue and reimbursements may be considered outside the annual debt limit. It seems that the purpose of that is to advise the council, this is how you should proceed. This is sort of what you have to work with. That I'm going to set it at 28. I know that it was increased to 35 million. But that we had this sort of collaborative relationship where the controller is advising the council on what to do. And then it seems to me the council tried to abide by what the controller had recommended, had then asked that she send them, her office, to send bond resolutions to the council in certain amounts and it was way over 28, way over 35 million, because they recognized that many of the projects, the school district projects, and then the third tranche public works projects, those were reimbursable. So it seemed like they're working along, but then after they sign it and the bond resolutions come over from the controller's office, the resolutions the controller sends over uses the words direct. We direct you to do it. So then they sign those, they send it back, and now suddenly it stops. And it seemed to be a sense of surprise by the city. If the controller had known that she had the authority going back to 1945 to do it, why isn't that included in the very first report, the August 1st report, saying that this is how you're going to be limited? And that's the first question. I guess the second part to it is, why then send over the bond resolutions that she's not going to approve anyway?
There were several things in that question, and I'm going to try to remember each of them. First of all, a lot of those questions are answered by the 2018 Capital Debt Management Policy, which we've uploaded a day after our argument, 2 days before the decision. Mr. Connors contests that, but it's a matter of public record. You can just go on the city's website, so you can take judicial notice of that. That reinforces more recently what's in the 45 and 94 reports. Second of all, if you look at the city charter 20-21, that's where each August 1st, there's to be an estimate of what can be prudently incurred. Now we have various numbers floating around. We have 28, which is what the controller said on August 1. Later, she said, if you really want me to go to higher, I could go to 35. The mayor came in at 110, the acting mayor, for the 1 year of one complete year of his service at 110.
But the 110 included reimbursable projects, what the mayor believed to be reimbursable projects. If you take those out, the mayor's at 27 or 28, 29, somewhere in there, well under the 35.
Let me address that. If you look at her August 1st letter, she says they may be reimbursable. If you look at her affirmation, she goes in 53, 54, and 55 paragraphs and talks about all the things that can go wrong with reimbursement. The reimbursement's not a sure thing. The reimbursement is anticipated, but things happen. I mean, look at our federal government. If you're counting on federal money, you don't know what's going to happen.
At what point is it the controller's responsibility to explain that process to the council and say, these are reimbursable, these are not? Is the answer no?
Her November 14 letter goes far beyond the August 1 letter in 2024. And that spells out her thoughts, including the fact that she's troubled by the money that's been borrowed and not spent, on which the taxpayers are paying interest. That's November 14th letter.
I have it. It's only 2 pages. It brings up new issues. The American Rescue Plan Act funding being over, fiscal pension payments. It doesn't talk anything about what's reimbursable and what's not reimbursable. It brings in all these other issues. Frankly, it calls into question as to whether her $28 million figure might be too high. And then she ends it by saying, but you can increase it to 35. I think I'm more confused by the 2-page November 14th letter than I was from the August 1st one. The August 1st one, actually, I wasn't confused at all. It seemed fine. It seemed it's reimbursable. It doesn't necessarily count. And if it does, I'll tell you why later. But we never got that.
But you stated it properly, not necessarily count towards the debt limit cap. And she says on November 14th, she is counting towards the debt limit cap. And she says in her affirmation in September of 25, she's definitely saying that the tranche 2 and tranche 3 do count towards the 28 million that can be prudently borrowed.
It would have been a little easier, I think, for the city had she said, you know, you're all misreading the statement I gave about the reimbursable projects. You don't take that as, you know, that's carte blanche. Like we have to talk, like it would have been nice to have some explanation of that. I don't think we've ever seen that.
Let's remember, this is coming from the comptroller, not the corporation counsel. It's not from Cavett Chambers. It's from Barbara Miller Williams. And for a non-lawyer, I thought it was legally competent.
No, but there's attorneys at the disposal of the office, right?
And she could lose the corporation counsel's office.
Fair enough.
But
the second part of my question, I very much appreciate you trying to handle a multi-part question, but the second piece was when she sends over the draft bond resolutions before they're signed by the council and includes the word direct, we direct you, which is basically sending over a draft that's asking the council to direct her office to sell the bonds. Why does it include that language?
I wish this weren't on an expedited basis of an Article 78 because the record is not as well developed as I would like. I, standing here, have never explored that with my client, and I do not know the reason, but I would not be surprised if that language did not come from the Corporation Counsel's office, but was originally done by bond counsel Hawkins, Delafield, and Wood. But I cannot stand in front of these judges, and I know all of them. I have never discussed that matter with Miss Miller Williams.
But Savino, your time is up. If you want to wrap up real quickly, please.
Your Honor, in closing, and thank you for giving me that admonition. Finally, we can't lose sight of the fact that respondents must demonstrate a clear legal right in order to be entitled to a writ of mandamus. So if there's any ambiguity in what the Common Council intended in 94, when it delegated the comptroller its powers, quote, with respect to making determinations to issue bonds, close quote, the lower court's decision must be overruled. And thank you for your patience with me.
Thank you.
Good afternoon, Your Honor. Terry Connors and Andy Debbins appearing for petitioners Scanlon and Nowakowski. You know, the pertinent questions that came from the bench caused me to change my introduction to you because you're right on point. Honestly, can you believe that the comptroller, when there's validly enacted legislation directing her to do something, that branch of government could just say to the Common Council, the Finance Board, the legislative branch, no, I'm not going to do it. I'm not going to do it. That's what she did here. You know, imagine a city where you have a mayor who makes a legislative proposal. And as you know from the record in this case, the legislative proposal was the subject of a very thoughtful memorandum. He wanted to be bold. He wanted to help the infrastructure. He wanted to do things perhaps that haven't been done before for a city that sorely needs it. You make that proposal, you let the Common Council take a look at it. They look at it and they say, We agree with you. We absolutely agree with you. 6-1 was the vote, right? In the meantime, the comptroller has the ability to disagree. She can send a 10-day letter and say, hold on, let's be a little more conservative. Be careful. They got that letter and they said, no, the vote came after her 10-day letter. They said, no, we're going forward with this. She has the right to disagree, but not to deny.
If there was some illegality, like the constitutional debt limit, maybe a different matter.
Exactly. If
But
it was invalid, inappropriate, there was some, that's the way the challenges are in the case law.
Expect that they be the petitioner here, not you, that they would come in and say they're directing me to do something that I think is wrong, improper, etc. I'm kind of confused about how we got here, you being the petitioner.
You're absolutely right. You know why? They don't have the power. They can't come in here because they don't have the authority. They don't have it from the resolutions. The resolutions are the straws that they're grasping onto to try to supplant the legislative power, the branch of government to interfere with it. Classic separation of powers.
Okay, but I would be remiss if I didn't ask you to address Mr. Savino's thought process here that this power was ceded to her sometime a long time ago and hasn't been taken back. Could you address that?
Happy to do that. Two resolutions that are at issue. September 4th, 1945, before I was even born, refers to many sections of the local finance law, but it doesn't treat them all the same. If you look at that resolution and you parse it, you see that it does not delegate all of the Common Council's power. Let alone the crucial decision-making power about debt. It says Section 50, 56, 57, 58, 59, 60, 62, 63, and for some reason 164 comes in after that. These are the administrative decisions that have been delegated. The how-to, the terms, the content, the form of the bonds, within her wheelhouse. She should have the discretion to do that. But they explicitly do not delegate all of the power under Section 30 of the local finance law. That's where it comes from. That's the authority to issue right there in the statute. And they didn't do that. If you read the resolution, you see Section 30, some power. Then you see all of the power under this, all of the power under that. That's the power of the weather. That's the power of the authority to issue the bonds.
Would the legislature even delegate that lawfully, that type of authority?
Yes, they can. They can under the local finance law, they can. There's a mechanism for that, Your Honor. It's called the delegation mechanism. It's found in Section 30. That supports us even stronger. Because if that delegation is made, and it wasn't made here, but if it were made, she then has the obligation to first file with the Finance Board, that's the Common Council, a certificate authorizing the issuance of such note. She never filed any certificate. So if she's really claiming that she has that power, where was the document that says I have that power? Because if she filed that, all hell would break loose at that point, because people would see it's an usurpation of something she doesn't have. She doesn't have that power.
Couldn't the Common Council just clear this up with a simple resolution and say, look, we had 45, these two resolutions in the past, we did not intend, and just clarify this, what power we gave them in plain English to just wrap this up, and this is all moot.
Well, I think that they feel it's clarified already. Perhaps in the future, maybe some council session with the advice of the Corporation Council may do that. But right now, we can demonstrate from her own words that she doesn't have that power. The other resolution, Your Honor, the November 1st, 1994 resolution, even more limited. It talks about Section 21. 21 is the issuance of serial bonds. You know what? That's within her wheelhouse. She should have that authority. She decide whether it's a serial bond or bond anticipation notes. She has supposedly the expertise for that. That's okay. That's okay. But it was the delegation how, not the whether delegation. And by the way, if she already had that power from the 45, why would she need the 94 resolution? It just doesn't make sense. It doesn't, in any event, neither resolution gave her the power. She doesn't have the power to refuse a direction, as you pointed out, Your Honor, authorized and directed. She can't refuse that. She doesn't have the veto power. She doesn't have the authority to say no. She doesn't have the authority to say zero, Justice Lindley, as you questioned her. And you know what? When you step back and think about it, it's a little absurd to think that a legislative body would delegate the power to another branch of the government to overrule their legislation. Say, we're going to give you, comptroller, the right to veto our legislation. It wouldn't make sense. It would be chaos. You wouldn't have the separation of powers that is so important. But there's three reasons why this delegation didn't take place. I've told you one, 30A, B subdivisions. My able counsel friend here talked about 30A. He didn't talk about 30B. Well, 30B says that's where the certificate has to be filed. And the failure to file that is evidence of her acknowledgement that she doesn't have that power. Right? And, you know, if they wanted to delegate power under Section 30, which is the true power, the authority to issue, they could have very easily done that. They didn't do that. It's clear. And number two, it just doesn't make any sense that a legislative body would delegate to another branch of government the right to veto their legislation, the right to overrule what is thoughtful, what is important to the city, what is the policy of the mayor and the common council. It's honestly, it's an absurd claim. The final one is that, you know, if you take a look at the fine print in the resolutions, and one of them is even hard to read, you need a magnifying glass, but they do say at the end, until such time as the common council by resolution elects to resume the same. Well, I think it was Justice Greenwood who said, didn't they just do that with the resolutions that were passed? They issued resolutions directing and authorizing her to do that. They made it clear. And if it wasn't clear, the statute supports us. 30C, which was not in any of my opponent's briefs. In such instances in which the chief fiscal officer, that's the controller, exercises such power, that's rightfully delegated power, if it were delegated, okay? The same shall be exercised subject to such terms and conditions not inconsistent with the provisions of this chapter as the finance board may prescribe. The finance board is the common council. So if in fact they delegated, and I say they didn't, they took it back with the resolutions that were subsequently passed. And finally, you know, if those arguments, all the case law we cited, we told you about the Kohalan case in the Second Department, which, if you know from the record below, Justice Kolyakov said to my opponent, what about Kohalan? How do you distinguish that? Well, it's spending, not borrowing, a distinction without a difference. That's the Second Department in 1983. He said, do you have a case that says the controller can do this, Mr. Savino? No. Do you have an example that says they can do that? No, they had none at all. And in addition to those objections that I've told you to the claim that she has the power to veto and to refuse, her own words establish that she knows she doesn't have that power. When we took her public proclamations, they're in the record, page 254. I can only recommend, let me be very clear, I'm a separate branch of government. I cannot direct or tell the other two branches of government what they must do. What an acknowledgement that we're right, and she knows it. If the ruling comes down that I'm required to, I'll sign under duress. Ministerial act. I'll sign under duress. You know what she didn't say, what she could have said at her press conference or at her Facebook post? I'm not going to do this because I have the power. It was delegated to me in 1945. I have the power because it was delegated to me in 1994.
I'm just having some problems here with some of the idea of consequences, okay? You know, being directed to do something and not having them done.
Well, the next move would be contempt of court if we were successful, right? And if she says,
I'm thinking more of fiscal consequences. You know,
they're
possible to
awful.
do things as you go on and
The
on.
consequences are awful. You know what she did? She went to market on her own choice of projects under the tranches. This tranche 1, 2, and 3. She ignored the Citizens Planning Council, which is a deliberative body that picks and ranks the priority of the projects. She said, I'm going to market on 29 million, which is over that crazy debt cap that she claims is not a debt cap because a debt cap is the local finance law. She goes to market and she ignores the Citizens Planning Council. You talk about consequences. Now we're in a situation where the city's going to have to pay more interest for construction costs. There's other issues about jobs. Just by this own irrational act on the part of the controller, invalid act on her part, we've compromised the city and much of the city's future as well. So I appreciate you allowing me to take the time. I would close just by telling you, the drafters of the charter and the New York legislation, they know how to confer veto power if they wanted to. They had the ability to tell her that she had veto power, and they didn't do it. And you know who they gave veto power to? Veto power went to the mayor. The mayor has the right, when the council passes a law, to say, I'm sending it back to you. I don't agree with you. Now, there's some collaboration, some discussion, but that was the veto power that they knew how to grant in our charter, the city of Buffalo, and they never granted her veto power. And I hope that you don't grant her the veto power either. So respectfully, I'd ask you to affirm the decision of Justice Koliakovo and let the city move forward as the legislation directed.
Thank you, Mr.
Thank you.
Mayor.
Sure.